Okay, can you all hear me? Let me know if you can hear me. Can you hear me? Okay, you can hear me, but you can't hear the actual audio from the feed. That's super cool. I'm happy about that. So good morning. Happy Monday. Welcome to the Courtroom Files Live, where we feel it's important anytime we can to start out with a little bit of a disaster. Hang tight while I try to solve this in real time and figure out what in the world is going on. Because I'll admit I don't know. Let's try this. Let me know if you can hear it. Were you able to hear that little bit of court? Please let me know in the chat. You can hear me. Could you hear the court that I just played? That's what I need to know. You heard nothing. Well, that's super cool, guys. Okay, hang tight. This all worked in the pre-show. What exactly changed in the last, 3 minutes? You got me, friends. That should be fine. That should all be fine. Hang tight. Tell me if you've got anything now. No court sounds. That's super cool. Because you should be getting it. Okay, so here's what's going to happen, friends. We're going to pause the stream. I'm going to do my best to figure this out. I'm going to leave it active, but I'm going to stop streaming and do some quick troubleshoot. Hang tight. I'm sorry. I don't know. Nothing has changed. I'm so...
Receptacle. Thank you very much.
Thank you.
Thank you. Yes, sir. Yes, ma'am. All right. All right, our next file this morning is going to be People of the State of Michigan versus...
Okay, friends,
Mitchell.
I'm back. How do we feel
Berkshire.
about this? Can you hear the court?
This is file number 25-14102, FH.
Yay! Okay. Let's start over, shall we?
Guardian, I don't know if the court wants the guardian to join us at the table.
Well, I'm sure that'd be great.
So, good morning for a second time. Happy Monday. Welcome to the Courtroom Files Live, where we are supposed to be a professional operation, but for some reason, things changed in the 45 or so seconds between the pre-show and the real show, and everything fell apart. So let's try again. This is Judge Elmore. I believe he's doing a sentencing, and maybe this time we can hear. Let's find out.
28th Circuit Court. This time, we're taking up the case, you may be seated. We are taking up next the case of People of the State of Michigan versus Amber Michelle Null. This is case number 25-13951 FC. Appearances, please, beginning with the Assistant AG.
Good morning, Your Honor. Michael Doby for the people.
Thank you.
Robert Hertel from Ms. Knoll for joins me at the table, Your Honor.
Thank you. Mr. Doby appears today via Zoom by permission of the court. Also here before the court this morning is Mr. Charles Kennard from the Michigan Department of Corrections, who is standing in today for Mr. Brian Potter, the agent from that department who has prepared today's pre-sentence investigation report. The court refers back to the prior appearances on the record. We are here now for a sentencing. There was previously a sentence issued based upon a pretrial agreement. The defendant withdrew that plea. Another plea was entered and accepted by the court. And now we're here for sentencing. We have before us now a pre-sentence investigation report. It was received by my office back on August 13th. Mr. Doby, do you have any amendments, corrections, or objections to make to the contents of the report, sir?
I do not, Your Honor.
Mr. Hartel, same question.
Yes, Your Honor. Only the comments that I submitted in my memorandum, if we could go over those.
Hold on.
Regarding the scoring.
Yep, thank you. All right, so first, this court received back on the 15th, the sentencing memorandum. And in that memorandum, Mr. Hartel brought up 4 challenges to the offense variables. The first one we'll take a look here is at offense variable number 3. It is currently scored at 100 points for the death of an individual. Mr. Hartel, your argument?
Yes, Your Honor. Speaking strictly regarding the charge of the possession, I do believe my client gave a factual basis on that, so we wouldn't be asking the court to consider the full contents of the police report. If I recall correctly, the factual basis was personal use. If the court wanted to ask more questions directly of that portion, we trust the court's discretion on that.
All right, and so for here, we're looking at offense variable number 3 is scored for count 2. Count 2 was the possession of an analog. And thank you. Mr. Dolby, any argument? And by the way, again, that's only as to count 2.
Correct, Your Honor.
Thank you. Mr. Dolby, any argument in response?
Your Honor, Your Honor, I concede that 100 points should not be scored on OV3.
I do think that there was a factual basis provided for that possession of the analog. There was no test, there was no admission, no finding of guilt as to delivery causing death. The court therefore will strike offense variable 3, reduce that from 100 to 0 points. Thank you. The next challenge made by the defense in its memorandum is as to offense variable 14 for multiple offender in the situation. Offense variable 14 is scored on both counts. Your argument, Mr. Hartel?
Yes, again, strictly looking at count 2, I do believe my client's factual basis was of personal use, not of anything involving multiple people. For the same reasons, I would ask the court to score this one at 0 for count 2 only.
Do you think it should be removed for count 2?
Yes.
Okay, thank you. I just want to make sure we just say that correctly. Mr. Doby, any argument in response to offense variable 14 as to count 2, which is currently scored at 10 points?
Your Honor, I concede that the proper scoring of OV 14 is as to count 2 is 0.
Court agrees and will strike offense variable 14 and reduce that down to 0. That thus far means we have a total of 15 OV points. However, I know that we have next the challenge by the defense as to offense variable 15, which is currently scored as at 5 points. Mr. Hartel.
Yes, thank you, Your Honor. Again, just for count 2, I do believe it would be appropriate to score this at 0 points. Her factual basis was to personal use. If I read the PSI correctly, the reason it was proposed to be added as the controlled substance has a value and is under the circumstances of trafficking. We don't doubt that there was value, but I don't believe there's any factual basis to trafficking. Thank you.
Your response or position, Mr. Doby.
I concede.
The court agrees and reduces offense variable 15 on count 2 from 5 to 0 points. That leaves us with a total OV so far at 10 points. However, now we turn to the fourth challenge. The fourth challenge is as to offense variable 19, which is currently scored at 10 points. One moment. Scored for the defendant's alleged attempt to interfere with the administration of justice. Mr. Hartel, anything further to add, sir, or maybe summarize for me your argument for the record?
Yes, thanks, Your Honor. Again, regarding count 2 only, I do believe that although the offense variable is properly scored for count 1, because there was no contest to that, and the police report does say what the police report says, I do believe the factual basis for my client, possession being personal use, I don't believe there was any finding just for that use that there was any deliberate cover-up or concealment, but we do, of course, trust the court's discretion.
Thank you. Mr. Doby, on behalf of the people, sir.
Thank you, Your Honor. I believe that 10 points are properly scored on OV19. OV19 is a variable that necessarily considers actions that occur after the offense is completed. So looking at the full picture of what happened after the possession, including the concealing the death and the steps that she took there, should be considered on OV19, and 10 points are proper.
Thank you. One moment. The court agrees with the government that the attempts to interfere with justice is not really when she fled the scene where there was evidence that may have led to her conviction or her identification. Being at the scene and present and using the controlled substances at that area, but there's information contained in even the PSI as well as the police report, which the court takes notice of, finds by preponderance of the evidence that the defendant not only fled the scene, but also encouraged other people not to call and get police to arrive to the scene that could have led to her connection to even being there and using substances. Therefore, the court will leave offense variable 19 scored at 10 points. That brings the total offense variable points down from 125 down to 10. That changes the offense variable score from a level 3 to a level 2. That means we are at now a 234. Yes. All right. Sorry, 2 to 25. I knew I was looking at that wrong. Thank you, Mr. Kennard. All right, we're at a 2 to 25 there. All right, Mr. Hartel. Any other challenges or objections to the content of the report or any other scoring factors?
No, thank you.
Thank you. All right, the court recognizes in the courtroom, which is pretty much empty, we do not have any additional victim impact statements that could apply to count one. All right, allocution, Mr. Martell.
Yes, Your Honor. Since the most significant portion of this, not that both counts are significant, but definitely the one with the most emotional weight, I'd say. It was a no contest. I'll be careful what I say as far as overly allocating at the start. But what I will ask the court to factor in is that my client has been doing things productively in the jail. In addition to what I wrote, I do believe our office social worker submitted some proofs, some letters of support, if I recall correctly.
I will acknowledge that I received that on Thursday. And when I say that, I mean what's titled a mitigation report. In addition to the memorandum, which we've already gone over, and I read through that. I will note that there were multiple letters from Ms. Cox, who is the social worker from Catholic Human Services that works at the Wexford County Jail. And I went through each one of those. And again, as well as the letter prepared by the social worker at the Public Defender's Office. Thank you.
My client is aware that addiction is a primary reason for her issues in life, including but not limited to the possession charge she did get the attachment basis to. We are, of course, aware as the court that she was out on bond for a very short period of time. She did have an issue due to her addiction, and the court did make a finding in that regard. She has been lodged longer than she's getting credit for because she was serving a sentence, but which again was connected to addictions. And she is aware of that. I do ask the court to factor that in when fashioning a sentence, that she isn't necessarily getting everyday credit for while she's been in there. But in some ways, I do believe in my conversations with her that her incarceration has probably saved her life as well. She's had the opportunity to get clean, to focus, in that little sliver of time where she got out, had those same triggers and demons come back and then have to go back in, I believe helps make her more supervisable, as kind of odd as that may be to initially hear. But she realizes now that I've heard it used before, maybe.
Pause for the noise outside. Correct. You may continue.
I'm not a medical professional and I may be paraphrasing it wrong, but I believe I've heard the term starvation syndrome, where people who get off drugs by force or other addictions, gambling, things of that nature, often will then go more than they would have otherwise, even though their tolerances went down. But because she had that experience and has had a chance to dry out again, and she does realize, she's realistic, that there is almost certainly more incarceration to come, but she is making steps and plans to prepare to be able to be sober when she is eventually. Be delicate and careful with what I say, not only because it was a no contest, but because of the loss that was involved in it. But just so the court is aware, my client is very cognizant of the fact that she has lost a friend and she will never be able to get that friend back, just so the court is aware.
Thank you. Mr. Dolby, any argument or comment?
Thank you, Your Honor. I'm sorry.
No, you're right. Thank you.
Yes, Your Honor. I've reviewed the recommendation of the department and I am in support of it. I asked the court to follow the recommendation in this case. The court received, I believe, a letter, a victim impact letter at the last time. I asked that that again be incorporated into the PSIR. The victim's family, the deceased's family, did not want to make a statement here, but I know the court has previously reviewed that. So I just asked the court to follow the recommendation.
Ms. Knoll, I know we've had kind of an up and down road to get to where we're at. Sorry, do you have anything that you wish to say?
I just want to say, I'm sorry. You just want to be.
Ms. Knopf, I think we ended up here in a spot where everybody wanted the case to go. And it's in a way that I think is supported by some of the evidence, most of the evidence here. when I last gave a sentence, I did so based upon what the facts of the case were, based upon the plea that was given. I also thought that based upon that plea, it would have been completely inappropriate for the court to support the agreement, because I didn't think the agreement matched the charges to which he had pled. That was a big thing for the court. I think we're now at a level that I think it's a lot more clear. I have read all the information provided to me by the victim's family, by the defense team. There's a lot of things to say here. And by the way, I know when I gave my last sentence, I highly suspected we would be here where we are now. So I refer back to several of the things that I said before, but I have to highlight them. We've got responsibility with the two children. I'll note that one of them, I think, was born after the passing of Mr. Johnson. Am I right? Was it in 2024 your son was born? I also recognize how the case got to where it's at. I know that as to the prosecutor's case, it largely hinged on one or two people that may have had some questions as to consistency, availability, would they appear? I know one of them didn't appear at the prelim. I know there were issues with credibility maybe, but there still was testimony and evidence out there that supported the offenses as charged. I don't sentence you for that though. This was a terrible situation. There's also kind of a black hole of information. I don't have, besides a couple of victim impact statements, and I assume it was one of them, the letters that I've got here in the mitigation report. It didn't say who M. Johnson was. I assume M. Johnson was one of the family members of Pat Johnson. Am I right, Mr. Dolby?
Yeah, yes, Your Honor.
Oh, all right, good, thank you. All right, well, good, that gave it a little bit more weight. I can't speculate as to what was really going on in the relationships between those involved, such as Mr. Ford, Miss Libby, Hugh, Mr. Johnson, the arrangements that had been made. I know here you were listed as a driver for him. Nobody's talked about whether or not you had a vehicle, because I think it was his vehicle, and I don't know. I'm pretty sure he was found in the driver's seat. Don't know if you were really a driver, but again, there's a lot of questions out there as to what the relationships were between the people. All right, so here, looking at your prior criminal history, you've got a growing significant criminal history that involves controlled substances and larcenies, which tend to go together. Peas and carrots, if I were to quote Forrest Gump. You got a lot of probation violations, bond violations in your past. Look at the criminal history here. It began in 2006. Less than 2 years later, you picked up your second. On that second charge, you got probation, and you made it about 2 months before you started committing a series of probation violations. You also had another case going on at about the same time, which had to do with larceny. Again, in that file, you only made it about 2 months before you started picking up probation violations. And then when you committed the probation violations, you actually picked up another charge of theft. That one was a retail fraud first, and yet again, within a relatively short period of time, you absconded on probation and then had multiple other probation violations. And those result in an additional criminal convictions. Look at it, and that your repetitive violations of probation, need for the courts to issue bench warrants, determinations of probation unsuccessful, was just an was like it did have about a 5-year gap between 2015 and 2020 when you picked up a drinking and driving. Then you picked up this case. Now, while this case was pending, I found it quite concerning that you picked up yet another case. So here you are after the death of an individual, whether it was a friend, employee, or some other relationship, you picked up another drug charge. And what also is quite concerning is you picked that up, and I don't know the date of the birth of your son because it's not in the report. Had to have been you were either pregnant or shortly after delivery of the child. So that's really quite concerning. You're still using drugs after someone has died in your presence. And you may or may not have been the one to help administer the drug to him that caused his death, but you're also pregnant and also using controlled substance. So your history with drug use is like that. Now, last time and back in September of 2024, when you were sentenced on the use of methamphetamine, your counsel obviously helped put down an end date for methamphetamine and so forth. And that was in 2000, you put on there 2024. Well, we know that you, by the way, were released on bond in this case, and you'd only made it 3 days on bond before testing positive. And then a couple of days thereafter, testing positive, maybe a second time. When I say maybe it was still in your system. I don't know, but still, it didn't take long for you to violate bond. So again, throughout your prior criminal history over the last 19 years, it has been a repetitive pattern of violating bond, probation, drug use, theft, crimes of dishonesty. Also putting other people, even a child, your newborn, at risk. This is a pattern for which you stop. At the age of 38, this needs to end. Not only for you, but also for others. And you can see how drugs are not victimless crimes. They impact family members, such as the newborn, also your 10-year-old. I found it interesting here that Mr. Ford apparently was involved in this case, must be the father for the son. But anyways, this impacts others, and it impacts Mr. Johnson, who died and whose death you tried to cover up. You fled. You told other people, don't call police, don't call ambulances, don't get him help. Just basically leave him out there till someone finds him or he rots. Drugs are not victimless crimes. Now, Ms. Snuff, I'm kind of talking slow and low because I know we've talked about this in the past, and I want you to get the message. I don't want to be overly negative because I know you have to listen to me basically be critical a second time, which I know can't be comfortable. By the way, in the mitigation report, yeah, you were doing pretty well with Catholic Human Services, which is why I let you out on bonds. All that rehab effort took you 3 days to violate. So now I'm learning also throughout your history, you've had CMH, you've had ATS, you've had Catholic Human Services, you've had addiction treatment services, and none of these things are working. You've got several medications that you're on for mental health and medical reasons, and yet you are supplementing those or adding to those opiates and methamphetamines. This lifestyle has to absolutely come to an end, or you're going to be the one who's dead next time. Remember. So here's what I want you to get, and I know, again, it can't be easy listening to me about this. You're making horrible decisions for yourself and your life choices. The people you choose to be around, how you get in those relationships and situations. I can't imagine that this relationship with the victim here was actually one that was a healthy relationship. I'm not gonna ask you questions about it. I'm just gonna ask you to think about it within yourself. How did you get into that relationship? Maybe making some bad choices. You've got kids who I know love you, and I want you to think of them every day and think positively about them, write to them, share with them your lessons, because someday they may face similar challenges and they need to see how mom finally reacted to them and learned from it. You're only 38 years old. I have to concentrate hard to remember being 38. So you've got plenty of time to live and make up for these challenges. All right. So again, this court finds that the reasonable proportionate sentence is as follows. The court assesses $268 state minimum fees, a $130 crime victims' right fund fee. I'm going to add no court costs, no attorney fees, no fines today. All right. I want you to get your time, and I don't want to make you paying that money contingent on you getting parole. I want you to get parole. That's why I'm not adding those fines and costs. All right, all right, for count one, the court sentences the defendant, recognizing that the defendant pled as a third habitual felony offender, which the court chooses to exercise its discretion and sentence her as a third habitual felony offender. That makes the maximum punishment up to 120 months. And the court sentences the defendant to a period of 30 to 120 months. A little less than what was recommended. The court gives 218 days of credit. As to count two, again, the court exercises its discretion to sentence the defendant as a third habitual felony offender. That makes the maximum punishment up to 48 months. And in that file, the court sentences the defendant to a period of 20 to 48 months. And again, the court gives the defendant 218 days of credit. Those sentences are within the guidelines. The court again finds them to be reasonable and proportionate based upon all the factors contained in the PSI, also discussed previously on the record and discussed today on the record. The court also orders that those two sentences run concurrently with one another, so they'll run at the same time. All right, have I missed anything, Mr. Kennard?
No, Your Honor, thank you.
Mr. Dolby
No, Your Honor.
and Mr. Hartel?
No, Your Honor.
Thank you. Mr. Hartel is going to bring to you, Ms. Knopf, 2 copies of one document. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of the document. This document tells you that you have the right to appeal the conviction and sentences in this case. Based upon the plea in this case, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your case of the document, or so your copy of the document. Again, I find that the sentence is not only within the guidelines, agreed to or effect agreed to or resulted by the parties, other than that one offense variable for OV-19 on count 2. I find the sentence again is reasonable proportionate. We had a death in this case. We had continued drug use, and we definitely see that the defendant has had issues with probations and so forth, and that just simply makes any probationary sentence inadequate. Thank you. Ms. Knopf, I really do mean this, and by the way, I know, like it's what I said earlier, can't be easy. I'm not surprised when I gave this the truth, and we are where we are today. Now I get to say to you, learn from this and all the things that I don't know about, those black holes of facts that I don't know about. However it got you there, and I can only speculate, but most of the speculation I don't use for sentencing. You know them. Figure them out. We're adjourned. Mr.
Okay, once again, hello everybody. Happy Monday. Welcome to the Courtroom Files Live. A little bit of housekeeping here real quick. First of all, Barbara, thank you for gifting a membership a little while ago. I didn't want to interrupt Judge and thank you right away, but thank you nonetheless. I really appreciate that. So our technical glitches when we got started this morning have been tracked down. I try to improve this show and this whole channel 1% every day, just a little better every day. So this weekend I installed a new monitor up above the camera where I can have the chat rolling or things I want to discuss or whatnot. So I'm more focused on the camera and not always down here on my monitors and be able to interact with you better. Well, for some reason, that device hijacked the audio routing, which is why we had a problem. It didn't present itself on the pre-show because I wasn't playing anything with audio, so never knew until I tried to go live here. That device has been disconnected for now. I'm back to my old workflow for today. We'll figure it out after the fact, but just wanted to let you know kind of what happened there. So we're going to go to Judge Washington's court because Mr. Magoo is there. Now, if you're not familiar with him, we've got a couple of videos on the channel from him. He's been in front of Judge Simpson. Judge Simpson bound him over to another court, not Judge Washington's, though. He bound him over to a circuit court, Judge Slay, I believe. But let's see what he's doing in front of Judge Washington this morning.
We'll see you on September 29th at 10. If you've made a payment, sir, then we're all good, okay?
All right, thank you.
Thank you.
Thanks, sir.
We'll call the case of the State of Michigan versus Daniel Magoo, case number 20, Magoo, case number 25S00289.
Tiffany Woods from People. Allison Muller here on behalf of Daniel Magoo. Mr. Magoo, can you go ahead and state your name once you're unmuted, please?
Good morning, Daniel Magoo.
Thank you. Good morning. All right, we're here today for a pretrial.
Yes, Your Honor. I met with Mr. Magoo last week at the jail, and we talked about our plan for this case and on his other matters that are in circuit court. I believe Mr. Magoo's next court date on those is going to be September 4th. I know they're having a bond hearing. So if we could ask for an adjournment, Your Honor, we just want to see what happens there and kind of talk further about what we plan to do on this case.
September 15th, 2025 at 9 a.m. Bond is continued. We'll see you then, sir, okay?
Thank you very much.
You have a good day.
All right, not much to see, but I saw his face pop up and I was real curious, so I thought I'd cut there. Let's go to Florida. Wade Mercer doing his morning docket.
Gracias, señor Delgado. Yo soy Jonathan Córdoba, el intérprete para esta mañana. ¿Usted me escucha bien?
Sí, lo escucho bien.
The defendant can hear as well.
Right. Mr. Delgado Flores, you're here because you've been accused of one count of driving under the influence.
Señor Delgado, usted está aquí porque está siendo acusado de un cargo de manejar bajo la influencia del alcohol.
Sir, there is probable cause for this charge.
Señor, sí hay causa razonable para la acusación.
And the criminal history I've got shows no prior criminal history. Is that accurate, sir?
Y señor, hablando de los antecedentes penales, aquí tengo que no hay antecedentes penales. ¿Eso es correcto?
Sí, correcto.
Yes, that's correct.
So you have never been charged with a crime anywhere. Is that correct?
Entonces, usted nunca le han acusado de algún delito en ningún lado. ¿Es así?
Así me-
That's right.
Mr. Ogata, you're potentially a candidate for a probation offer. The problem is that I don't see a social security number, so I'm not sure if there's going to be immigration issues.
Señor, usted es un buen candidato para libertad probatoria, pero siendo que no veo un número de seguro social, entonces no sé si va a tener problemas con la inmigración.
And I can't put you on probation if you're not going to be released.
Y no le puedo poner bajo esa libertad probatoria si no le van a poder permitir salir de la cárcel.
So let me ask Corporal Drown, any reason to believe, we heard anything from immigration? Is immigration involved in this case at all?
ICE has yet to respond, Your Honor. We sent them a notification. We still haven't got a response.
Entonces voy a preguntar al policía Brown, ¿hay alguna razón por la que sepamos que inmigración va a venir o no? En este momento no sabemos si inmigración va a venir. Todavía tienen que responder.
Mr. Delgado, what I'm going to do this morning is set you a bond in this case.
Señor Delgado, lo que voy a hacer esta mañana es que le voy a poner una fianza en este caso.
Your bond is $2,500 cash or surety.
Su fianza está puesta en $2,500. Puede pagarlo al contado o en fianza de garantía.
The jail typically will hold individuals till noon and give the United States Immigration Service that long to determine if they're going to place a detainer or not.
Le van a detener ahí regularmente hasta el mediodía. Así le dan tiempo para ver si inmigración le va a poner un orden de detención.
If they haven't placed a detainer by noon today, you are free to post a bond and be released.
Y para esa hora, al mediodía, no le han puesto un orden de detención, entonces va a poder pagar su fianza y salir.
If they do place a detainer before noon, then you know that they're wanting to detain you.
Pero si le ponen un orden de detención antes del mediodía, entonces ya vas a ver que lo quieren detener.
So if you're still in our jail, I will see you tomorrow at first appearance.
Señor, si todavía está ahí en la cárcel, nos vamos a ver entonces mañana en primera comparecencia.
If you post the bond, then I'm going to ask the jail to give you a notice for our arraignment date.
Si llega a pagar la fianza y sale, entonces va a pedir a la cárcel que le den una fecha para la próxima lectura de los cargos.
So,
¿Puedo hacer una llamada?
Can I make a phone call?
Just a second. The court date will be September the 30th at 9 a.m. No, excuse me. September 30th at 9:30 a.m. 9 y media.
Entonces la próxima audiencia sería el 30 de septiembre a las 9:30 de la mañana.
Do you have any questions?
¿Tiene alguna pregunta?
Ocupo hacer una llamada, ¿podría hacerlo?
I need to make a phone call. May I make a phone call?
Absolutely. You can make a phone call, but just realize that even if the bond is posted, you may not be released until noon today.
Así puede ser la llamada. Nomás tiene que tener en mente que aunque llega a pagar la fianza, no puede salir hasta después del mediodía.
Ok, nomás por si... A pedir lo de la fianza a mi patrón.
Okay, just so I can call and ask my boss to help me with the bond.
Okay. Sounds good. We'll see you tomorrow if you're still there, sir.
Está bien. Nos vemos mañana si todavía llega a estar ahí, señor.
Ok, gracias.
Thank you.
Barbara, thank you for gifting another membership. You're very generous and it's appreciated. So thank you.
Friends or family and an attorney here. We need to take that case next, and that is State versus Dylan Bracken. Mr. Bracken, come on up. Mr. Bracken, your attorney, Mr. Atkinson, is here on your behalf. And also your sister is in the courtroom. Mr. Bracken, you're here because you've been accused of one count of grand theft between $750 and $5,000. I read the complaint. There is probable cause, Mr. Bracken. Mr. Bracken, the criminal history I've got shows no prior criminal history. Is that accurate, sir?
Yes, sir.
All right, that's great. Let's see what Mr. Axon has to add, and then we'll see if Mr. Mitchell has any input. Mr. Axon?
Your Honor, that is correct. He does not have any criminal history. He is a young man. I believe he's 24 years old. Was notified that he had a warrant out for his arrest and did turn himself in. He works and goes to school. However, I'm sorry, he works at this point in time. And I believe that he does work in Alabama. So he would not have any problem signing any waivers of extradition. And he's not a danger to the community, Your Honor. I just asked for a low bond in this.
Mr. Mitchell?
Nothing from the state. We have no objection to that.
Mr. Bracken, given your criminal history, I'm going to let you pick between a bond and the conditional release, sir. If you like to post the bond for grand theft that I set typically is, well, let me ask this question.
He wants a cash bond.
Does he prefer a cash bond?
I believe that is what it is. Is that correct, Mr. Bracken? You prefer a cash bond?
Yes, sir.
Okay, as long as it's not too high.
Well, if it's a cash bond, it's going to be $500 for that charge, or I'm all from a conditional release also. Mr. Mitchell, any objection to the cash bond?
No objection to a cash
So,
bond.
Mr. Bracken, if you prefer a cash bond, it's $500. You've got a condition, no contact with alleged victim. If you prefer a conditional release, we want to offer you a conditional release because of your history being perfect up until yesterday. Mr. Bracken, do you understand your choice between the cash bond and the conditional release, sir?
No, sir. I like the cash
Okay.
bond.
Okay, so you do understand the difference. You just want the cash bond, correct?
Yes, sir.
All right, so as soon as that cash bond is posted, you'll be released. We're also going to give you a notice. We haven't had one of these yet. So, Mr. Axon, as of last Friday, we started giving notices for the arraignment date at Judge Garcia's request. So I normally would give him a notice for the felony arraignment date. Have you filed a notice of appearance?
I have not, Your Honor.
I wonder if we need to give a notice for that same date or not. I think we'll give a notice for that same, Lindsay, you got any?
Same day.
Okay, if you're confident you're going to be filing notice of appearance, and I'm assuming you are since you're here, we'll just give a notice for that day. You okay with that?
Yep, no objection.
So we're going to ask the jail to give you a notice. In this case, it'd be a little unusual date. September the what?
2nd.
Yeah, he won't have discovery by then. What's the next one after that?
I have no objection.
October 7th. What time is that, Lindsay? October 7th at 1:30 is the date his notice needs to be for, Corporal. October 7th at 1:30. Mr. Bracken, make sure you stay in contact with Mr. Axon before that court date. Mr. Bracken, do you have any questions?
No, sir.
Ma'am, in the courtroom, do you have any questions? Mr. Axon, anything else?
Nothing further. Your
All right,
Honor.
thank you for coming over here. I see a felony attorney's the first appearance less than 10 times a year. So I'm glad to have them come over here for their clients. Not all of them will come for their clients. They'll just follow the written notice of appearance, but it says something, Mr. Axon, that he's over here protecting your interests this morning. So I wish you the best, sir.
Thank you, Your Honor.
Thank you, sir.
I believe that's all I have. If I'm be excused.
Thank you, Mr. Axon. Yes, sir. All right. I think that's it for friends or no, it's not. We have Rodell, Kaylee Rodell. Wish you the best, Mr. Axon. And Mr. Rodell's mother is here. Miss Rodell. Miss Rodell, good morning. Miss Rodell, your mother's in the courtroom. Miss Rodell, the first thing I've got to do is get your spelling of your name correct because I've got it spelled two different ways. The complaint has Roedel. The jail first appearance sheet. Okay. Jail first appearance sheet has Rodel. It actually has two E's in your last name, correct?
Yes, sir.
So, Corporal, if you can get your jail records corrected, we'd appreciate that. Ms. Rodell, you're here because you've been accused of one count of driving under the influence, ma'am. There is probable cause for that charge. I'm going to appoint the public defender's officer to represent you. I think I told you, but your mother's in the courtroom. Ms. Rodell, listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor, I've talked to Ms. Riddell. She's going to enter a plea of no contest to the charges as listed. She'll be adjudicated guilty, 11 months, 29 days probation, $1,078 in fines, 50 hours of community service, DUI, school, AA counseling as directed by probation, and a minimum driver's license suspension. She has signed her plea waiver form, waiving the right to a jury trial and call witnesses.
Thank you, Mr. McDaniel. Ms. Rodell, did you hear that agreement?
I did.
Do you have any questions about that agreement?
No, sir.
Ms. Rodell, is that the plea that you would like to enter, ma'am?
Yes, sir.
Mr. Mitchell, is that all agreeable with the state?
It is, Your Honor.
Ms. Rodell, I'm going to accept your plea of no contest to the charge of driving under the influence. I'm going to judge you guilty of that offense, ma'am. I'm going to sentence you to 11 months to 29 days probation. Mr. Odell, you'll have the standard conditions of probation, plus the conditions required by Florida statutes, which are $1,078 court costs and fines, successfully complete substance abuse counseling, 50 hours of public service work. I do recommend DUI. I do require DUI school. I do recommend the minimum driver's license suspension. If you choose to do AA or NA, we put a cap on the 12 classes. And Mr. Odell, it's possible to get off probation early. The way you get off probation early, ma'am, is you do half your supervision. In your case, that'd be 6 months. And if you have no violations, you've got everything done, there's an excellent chance of you getting off probation early. So what's going to happen next, Mr. Odell, is you've got to be brought to the probation office, which is here at the courthouse. So talking to your mother now, so ma'am, they're going to let her get dressed back in her regular clothes. They'll bring her to the courthouse because that's where the probation office is at. It's on the first floor on the east side. Probation office, Mr. Goodson or Mr. Ham will meet with her. They'll go over the probation with her. They'll give her a copy of all the rules in writing. They'll give her a chance to ask any questions, and then she'll be free to go. And usually that's 30 to 45 minutes from now by the time they get her here. To your mom, do you have any questions, ma'am?
I do have questions. I don't really have questions, but she does have pending charges.
I saw that she had pending charges, and I noticed that in the state of Alabama, right? So I used to hold people for a period of time to see if Alabama would file some kind of warrant or bond. And I have never had them do it, especially on a misdemeanor case. I don't think I've had them do it in a felony case. They have a grand jury system in Alabama, so typically it takes much longer to get through the process. So I don't even hold them anymore because it's so unlikely. They would sit there for 10 days. I never had not one single case where Alabama would get a warrant within 10 days. So Mr. McDaniel asked me to stop doing that for basically wasn't accomplishing a whole lot. And I agreed a couple of years ago. So you do need to make the Alabama authorities aware of this arrest. I have no idea. If you check in with your bond, let your bondsman make sure your bondsman's aware of the arrest and your attorney. Not those individuals deal with it, Mr. Odell, and what they do is up to them. But you've got probation here, and I expect you to complete the probation. Do you have any questions, ma'am?
I don't.
All right, ma'am. We'll see you at the courthouse in a little while. Are you going to be able to pick her up, ma'am? Your mom said she's got transportation covered, okay?
Okay, thank you.
Yes, ma'am. We have Christopher Johnson.
Yes, sir. Yes, sir. Yes, sir.
Mr. Johnson, good morning. Mr. Johnson, looks like you were first appeared and either myself or another judge held you 7 days to see if there's a violation of probation warrant. And Mr. Johnson, there is a violation of probation warrant that was signed by Judge Garcia on the 21st. So what I'm going to do today is I want to go ahead and get you arraigned because I want to get you a lawyer appointed to represent you if that's what you're asking for. And this is in the VOP case. Would you like to have an attorney appointed to represent you, Mr. Johnson?
Yes, sir.
I'm going to appoint the public defender's officer to represent you. Listen to Mr. McDaniel, and then we'll see if you have any questions in just a moment.
Your Honor,
Yes, sir.
plead not guilty. Asked to set this on the September 4th pretrial docket, arraignment docket, or pretrial docket. And I've already advised you, Mr. Green, to come out and speak to him prior to that hearing.
September 4th. And Mr. Mitchell, anything from the state?
No, Your Honor.
Mr. Johnson, any questions?
Yeah, I'm my mama talked to Stephanie. I'm trying to get some real help this time, man. I'm trying to get drug court this time because I really need some help this time. I just can't. I don't know. I need some
Mr.
straight
Johnson.
rules. That's all I gotta say.
Mr. Johnson, just
Yes,
talk to
sir.
Mr. Green. I told you before, talk to Mr. Green.
So
Yes, sir, I
they'll
will.
talk to you. They'll talk to you about that possibility when you get over to felony court, Mr. Johnson. I wish you the best, sir.
Yes, sir. Yes, sir. Thank you.
Yes, sir. After Mr. Johnson, we have already seen Mr. Odell. I believe that brings us to Heather Bailey. Ms. Bailey, good morning. Ms. Bailey, you're here because you've been accused of 1 count of trafficking in methamphetamine, 1 count of introduction of contraband into a state correctional facility, and 1 count of possession of cannabis with intent to distribute. Ma'am, there is probable cause for all 3 charges. Corporal, I couldn't tell. It says bring back today to the missing paperwork. Do you know what the issue was from the weekend? I know that you weren't on duty, Corporal, but I have no idea.
I didn't realize it was a front and back affidavit.
Oh, they only copied the jail. Yeah, and those are very unusual. So, Mr. Mitchell, if you would contact the inspector that did this, the detective, I'm not sure why he sent it front and back, but I don't know that I've ever seen that. So it doesn't need to do that because what happens is the jail in there, they put it in their copier and they hit copy. It doesn't copy front and back. So what I think happened is the first appearance judge only got the front page, which doesn't have anything on it. So if you can ask the inspector in this case to not do that, that'd be great. So Ms. Bailey, I've read the whole complaint. There clearly is probable cause, ma'am. I think you're entitled to a bond as far as I can tell because you have little or no prior criminal history. The problem is, Ms. Bailey, that you're accused of a first-degree felony, which is a very serious charge, and some other serious charges, but especially that first-degree felony. Ms. Bailey, let me see if the attorneys have any additional information, ma'am, then I'm going to set you a bond in this case. Mr. McDaniel, anything?
Nothing, Your Honor.
Thank you. Mr. Mitchell?
We just request you be subject to random UAs.
Ms. Bailey, I'm going to set your bond at $50,000 on the trafficking. That's a first-degree felony, $10,000 on the contraband, $5,000 on the cannabis. Your total bond today, ma'am, is $65,000. Ms. Bailey, that's cash or surety. Cash or surety means you don't have to come up with all the money. You can go through a bondsman. That's what a surety bond is. So, Ms. Bailey, after first appearance, you'll get to use the phone, ma'am. If you post the bond, you're going to be released. If you don't post the bond, then the public defender's office will be seeing you at the jail, ma'am. But you've got a total bond of $65,000. Last thing, I want to ask the jail to give you a notice for your arraignment date, ma'am, which will be September the 2nd. September 2nd will be your arraignment date. So if the state hasn't filed charges for you, that would just be a case management date. But they're going to give you a notice for September 2nd. And those notices, we just started this last week. Is it 9:30 or 8:30? I can't remember.
I think it's 9 o'clock.
Is there notices for 9 though? No, it was a 30. It was a media.
8:30.
Yeah, so the notice is for 8:30. That way, if she posts bonds, you know she's got to be here at 8:30. Court starts at 9, but your notice will be for 8:30 on September 2nd. Ms. Bailey, do you have any questions, ma'am? You do have a condition of random urinalysis. Any questions, ma'am?
No, sir.
All right, ma'am. Wish you the best. You'll get your phone shortly. Christopher Nicholson.
Yes,
Mr.
sir.
Nicholson, good morning. Mr. Nicholson, you have a warrant out of Bartow County, Georgia. I know that you've had a chance to talk to Mr. McDaniel about the waiver of extradition process. Do you have any questions about that process?
No, sir. I just thought it was 72 hours that they had to come pick me up.
No, it's not even close
Because
to
in
that. It's
Georgia,
30
it's
days.
72 hours.
Yeah, it's 30 days for out-of-state warrants. I think that's got to be every state. There's no way somebody could pick you up from California and Georgia in 72 hours. It's impossible. So it's 30 days, and it starts the day you sign the waiver of extradition. And under Florida law, it cannot be signed until you're in the presence of a judge. So, Mr. Nicholson, do you have any questions about that process?
No, sir.
And do you want to waive extradition and go deal with these issues that they're accusing you of in Bartow County, Georgia?
Well, yeah, I want to go ahead and get it taken care of. I've already made bond on the charge.
Okay. Well, once you sign this, I'll see if you have any questions. I'll explain to you what happened from here. Mr. McDaniel, you satisfied he's doing this freely and voluntarily?
Yes, sir.
Thank you. So, Mr. Nicholson, they have 30 days from today to get you. If you're still here in 15 days, you come back to first appearance. And the reason for that is so that I can get an update from the jail on the communication with that state, and you'll get to hear it also. That's very rare. The vast majority of the time, they're going to have you back in their state within 5 to 7 days. That's probably on, if it's close. I'm not sure where Bartow County's at. Do you know the county seat for Bartow County?
Bartow County is about an hour an hour and 15 minutes north of Atlanta, Georgia.
I would say 5 to 7 days, but just to be on the safe side, if you're still here in 15 days, I'll see you. And when you get there, the judge there will address your bond. Any questions?
Yes, sir. No, sir.
Wish you the best, sir. Have a good day.
Thank you, sir.
Yes, sir. After Mr. Nicholson, we have Stephen Keith. Mr. Keith, good morning. Mr. Keith, you're here because you've been accused of one count of obstructing an officer without violence and one count of loitering or prowling. Mr. Keith, you also had a 5-day hold from the weekend for the first appearance judge. Mr. Keith, I'm going to appoint the public defender's office to represent you in the new charges. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I spoke to Mr. Keith. At this point in time, he's going to enter a plea of no contest to the charges as listed. The understanding, he'll be sentenced to 60 days in the county jail, 2 days jail credit, $370 fine, be adjudicated guilty, and this will resolve this case today.
Thank you, Mr. McDaniel. Mr. Mitchell, anything from the state?
Yeah, that's agreeable with the state.
All right, Mr. Keith, any questions about that agreement?
No, sir.
And Mr. Keith, is that the plea you would like to enter, sir?
Yes, sir.
Mr. Keith, I'm going to accept your plea of no contest of these two charges: obstructing an officer without violence and loitering or prowling. adjudicate you guilty of those two offenses, sentence you to 60 days in jail on each case concurrently. 2 days credit. Mr. Keith, I'm going to impose court costs and fines only in count 1 of 370. Waive the court costs and fines in the lowering case. Mr. Keith, you have 58 days left. You very well may do less than that under Florida's game time law. So talk to the jail about that and their trustee program. Mr. Keith, I wish you the best. Any questions?
No, sir.
Have a good day, sir. And I think that's it for first appearance purposes. Anybody I may have missed?
No, Your Honor, that was everybody for this morning.
Thank you, Mr.
All right, as he's wrapping up, let's go ahead and go to Texas, and we'll say good morning to Judge Stevens.
Hey, Judge, I was getting hired last month, and I didn't realize it was on the trial docket. I mean, I understand.
It's over a year
I
old.
understand it's older, but
Well, I mean, that's waiting for the last minute to, we're on the trial docket, either ready or not. Y'all talked about it, where we headed.
Judge, I think, I don't see it really being a trial. I haven't got into it deep enough yet to know for sure.
And once again, it's the, see, the problems with this is we got victims who say, what the heck? How long does it take? And this says it's serious bodily injury occurred in this. So with the Victims' Rights Act, we got to move on after a year and a half, 432 days time. You're on the trial docket. You're on the trial docket, and it's in its slot. It'll be in the back. You're in the slot. At this time, y'all got to be ready to move forward.
Yes.
And then finally, Trevante Moten, please, Mr. Lewis.
That was
It's ready.
All right. Let's take Mr. Moten on Marvin's cases, please. Let's get these things out. So
One-
we'll know. And then the rest are going to
Be
be.
the very last one.
All right. It's Mark.
Deadly conduct, this one he's pleading to, or the rest of it, yeah.
Michael, thank you for gifting that membership. Very much appreciated. Everybody, go check out Michael's channel if you have not already. There's
We now
already a
call
link in the
22-39866, the state of Texas versus Trevante Marquise Moten. You're Mr. Moten. Present with Mr. Lewis, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
He does only two.
In summary, this indictment alleges that on or about November 8th, 2021 in Jefferson County, Texas, you committed the third-degree felony of deadly conduct. Do you understand what you're charged with here? And that was knowingly discharging a firearm at or in the direction of a person. Okay, a third-degree felony means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable here, sir? Yes. Marvin, you had trouble with this tablet too. We're getting replacements, thank God. These things are all worn out of something. Can't touch them without smudging, and then it marks all over. An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length, fined $1,000. You do well on probation, your probation term is cut into 1/3 of it. You're going to do well, right? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, sir? Guilty or not guilty? Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I'm going to show you what's marked as State's Exhibit 1 here. Did you sign this document voluntarily? Understand it, discuss it with your attorney. Put the phone up. Good Lord. You can't follow any of the rules. Sir, there's a sign that says don't bring cell phones in the room. That's where you're sitting over there. You can't follow any of these. I'm gonna, what are they showing us? For him? What are they showing up for him? He needs to be tested. He's got problems.
I'm not sure.
Call him up.
Yeah.
Probation?
Justin.
Get somebody over here, please. Thank you. Thank you.
He's on his way. He's on his way.
All right. How do you plead to this again? Are you pleading guilty voluntarily and because you are guilty? Okay, I'm showing you what's marked as State's Exhibit 1 here. Did you sign that document? Understand it? Discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 is tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are totally satisfied with the representation provided by your lawyer, all true, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived here.
Yes.
I'm going to follow this agreement, sir, with nothing further to add. I'm going to find today you are pleading guilty voluntarily to this third-degree felony. If that the conduct you are mentally competent to do so, you understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, but I'm not going to do that. I'm going to defer any finding of it, postpone, so long as you follow these terms and conditions of probation, which are the terms and conditions of life I follow, all of us follow. Don't get in trouble, and you will be fine. The probation officer is going to go over all of these. You will be fined $1,000, which you pay over time. And make sure you follow these terms and conditions of probation. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 10 years in prison. And you've never been arrested before, have you? I don't see anything. You don't have any convictions? Okay, yeah. This is 8 years, not 10.
Okay.
8 years. So in a 30-year time, it'll be less than 3 1/3. Okay, follow those and you'll be fine. Okay, please see the probation. Hey, Marvin, be careful of that. Okay.
Bailey threw down a gift membership. Thank you, Superstar. Appreciate your support. And everybody liked your cooking during the pre-show, so that was good too. Let's get back to Judge.
Man, this thing is slow today. On these dismissals, can you automatically dismiss them?
All right, well, he waits for his next contestant. Let's stay in Texas, but we'll go say good morning to Judge Boyd.
So they're just here for a bond issue. This case is actually set on September 23rd for discovery. So anybody can file motions at any time and request that they be heard. So that's why it's on the docket. All right, so they're asking for no contact. Before we go on the record, do you have any objections to a no contact order?
Absolutely, Your Honor.
All right, so we'll go on the record.
Thank you.
All right, the court is calling 2025 CR 001961 State versus David Lopez. Could I have parties announced for the record?
Ashley Jones for the state.
And Eric DeWalt, and I represent Mr. David Lopez.
And are you Mr. Lopez?
Yes, ma'am.
All right, so we're here because the state has filed a motion for a no contact order as a condition of bond. They're stating that the judge who entered the bond did not place any conditions on you as a condition of bond. The state is asking for no contact with the complainant. Is that the only request?
At this time, yes.
All right, so, and off the record defense, you said that you were opposed to that.
I am, Your Honor.
All right, are there any witnesses?
No, Your Honor.
All right, the court will hear argument. So they
Possibly if need be witnesses.
That's
Sorry, from defense.
All right.
Need be.
It may need be. All right, all right. So do you have any witnesses to call today or no?
The state does not.
Okay, then I'll call Sue Lynn King.
But you're back against the county.
All right. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. If you'll state your name for the record and spell your last name.
Sue Lynn King, AING.
All right, you may proceed.
Ms. King, I was appointed to represent David Lopez, and you understand what he is charged with, is that correct? He's charged with aggravated sexual assault of a child, and you've seen the indictment. He's also charged as a repeater, is that correct?
Yes,
And have we talked about that repeater allegation?
yes,
Have you seen the judgment of the repeater allegation?
yes, I have.
And is the picture in the judgment of David Lopez?
No,
Is the date of birth of David Lopez?
no,
Is the height of David Lopez?
no,
Is where he served and he was ultimately found guilty in Harris County? In your knowledge, has David Lopez, your David Lopez, ever been to Houston?
he's been in Houston, but he never lived in Houston.
Has he ever been to prison?
No,
Okay, so the repeater, when he got placed on bond, this bond amount reflects an aggravated sexual assault of a child with a repeater allegation, correct?
yes,
And he's out on $100,000 bond?
yes.
How did that?
I'm sorry, just on that. Excuse me. Did you print out the indictment for me? Thank you. I have a copy. No problem. Thank you. All right, you may continue.
Now, you understand the allegation against David Lopez, is that correct?
Yes, sir.
Who is the alleged victim in this case?
My granddaughter.
And you took over custody of your granddaughter. Why?
They were in foster care due to
Let me stop. They, who's they?
all three girls.
Okay, so there is Phoenix, and she's the oldest. There's Annabelle.
In 2016 and brought them to Texas from Tennessee due to their grandmother and her brother molesting them. They were taken into state custody. Phoenix came out with a lot of issues psychologically. He was in counseling from the beginning and is still in counseling.
You have dealt with CPS on multiple occasions, correct?
Yes, they were always in my home at the time the girls were brought in.
But you have complied with all of CPS's requirements, safety plans, and anything. You've always been available to speak with them, correct?
Always.
Okay, and it was CPS that allowed David to come back to the house, correct?
Yes, it was.
Now, at any time or on multiple occasions, did Phoenix recant her story?
Multiple times to me, and then she had she went back to child save and recanted all of it.
Just one second. Let's pause for a moment. Because I have an idea that she's going to say that she wants him there. She doesn't want the no contact order. So does anybody have any way to have the CPS worker zoom in?
The state can speak to that. We do have CPS records. I have reviewed them in full. CPS, I guess their concerns were illegal because cameras were put up in the homes.
Well, no, I mean, does anybody have a CPS worker to zoom in for me to listen what the CPS worker has to say?
No, I just
Is
have a
that
CPS
possible?
report.
No, Your Honor. So I do.
All right, and then with regards to the indictment, sorry to interrupt your cross, but these are questions as I'm hearing their testimony that I would like answered. With regards to the indictment, is the indictment correct?
No, Your Honor, there is an incorrect birth date on the repeat offender enhancement. So the state would be filing a motion to amend the indictment to.
And have you all had a chance to speak to the complainant?
We have, Your Honor, and this in GROFF record.
Yes.
Okay, the state's concern is that the complainant has been with the defendant in the home for the past year and a half. And so speaking with the child under those circumstances is not ideal.
Okay.
And if I may, Your Honor, speaking off the record, like the state, I've talked to the state. They filed this motion to amend conditions while getting ready for trial. And I believe Ms. King went and talked to them, took Phoenix in after. I've spoke to the state. I think the state told Ms. King, I doubt the judge will rule on this, but I know how severe this is. CPS let him back in. They put up multiple cameras
17 inside the home.
around the house. And David also watches the other two kids, which both have autism. And every time he's out of the house, the kids revert back. This allegation came out in 2022. The investigator said that she recanted back then, but I'm going to go ahead and turn it over to the DA for review. And they didn't file until 2025. So I'm hearing all these stories, and I've met Phoenix, and it is a complex case. She has multiple personalities. She talks to multiple individuals. I've had ad-link conversations with her. She's the sweetest thing that has been tormented, but it is so wrong to be wrongfully accused on an allegation of this severity.
All right, so this is what I can tell parties I want. If somebody will pick up the phone, call the CPS worker. And was there a child's ad litem involved in this or no?
Not that I saw, Your Honor, throughout the CPS records.
Any attorneys? It's an attorney for the children.
They offered one,
Mhm.
and it never went through for some reason.
All right, so someone can have, because here's my thing, I will listen to your testimony and I always keep an open mind, but it appears that she's going to say she doesn't want the no contact order, am I right?
Yes, sir.
So I would like to hear from the caseworker. They're supposed to be objective. And I want to hear from them rather than just reading words on a page, because sometimes I have questions. So do y'all want to see if you all can call the caseworker? I'm sure they would zoom in.
State.
And then if you want to continue with your questioning of her, I'll listen.
I believe the judge kind of cut to the chase.
Yes.
You want David at home.
Yes,
Do you need David at home?
we do need David at home.
Do
I'm a full-time nurse. I work sometimes up to 16 hours a day, 6 days a week. And his parents are also in the home, the grandma, they're also in the home, but they're 83 and 85. And they cannot physically handle the two youngest girls because sometimes whenever their mentation strikes, it gets completely out of control. David handles them, sits them down in the living room, turns on a movie in the living room, kind of keeps them all pretty much stable. Phoenix comes down, she sits in the living room on the couch on the end and watches TV with them. It's a family interaction. I can see everything they do in the house.
Let me ask you this, has David ever alone with Phoenix?
Never alone with Phoenix.
Are there cameras that there are boundaries in the house?
There are boundaries in the house. If David is downstairs by himself, Phoenix does not come down because of the interaction whenever Phoenix had it first. And then David being accused, we don't want that accusation to be able to be brought back up.
And lastly, has Phoenix made an allegation where it is clear that David is out of the house and it could not have happened?
There have been a couple of times whenever David wasn't even in the house, he was at work or he was busy with the church working on beds and stuff, where she said that he's done something and my son's been present in the house and has told her that didn't happen. He was in the backyard working on a playground for the younger two, and she accused David of something that he didn't do because she'd never been outside and David was only outside, and she accused him at the time he was working on the playground himself. Joseph was on the back porch watching, and she blatantly made an accusation against David that didn't happen.
In your opinion, do you think the children are safer with David in the house than David being out of the house?
Yes, I do. I think that they have developed such a relationship that taking David out of the house, the youngest one actually reverted back to peeing on herself and peeing in the bed and unable to focus at school.
And how old is she?
She's 9, with a mentation about a 3 to 5-year-old child.
All right.
Other questions?
Any questions, State?
Yes. So when David was arrested for this back in 2024, is that when that
Yes.
out of county?
Yes.
And since that time, actually, since 2023, he's been in the home with you
Yes,
After these allegations came out.
yes, because the court's cleared him. Or not the courts, but CPS.
All right, so I have a couple of questions. Are there any objections?
Not in the state.
None from defense, Your Honor.
All right, so you say there are cameras in the house. Where are the cameras?
There are, 3 just down the hallway with the girls.
Mhm.
There's one in the corner above the bathroom that looks at the youngest children's door.
Mhm.
Because Mia sometimes has the tendency to come out of her bedroom and fall down the stairs.
Okay.
So there's a camera there and it triggers whenever somebody exits their bedroom. There is a camera in the corner of the hallway looking exactly this way, down the hallway where the gate is, down the hallway here where the girls' room is, and on Phoenix's door with the back.
So, correct me if I'm wrong.
Uh-huh.
So the only places there are no cameras are inside the bathrooms,
There are no cameras in the bathrooms.
but do cameras show anyone who's going into the bathroom?
Yes. And there are SD chips in each camera, so we can record and document anything that may come out as an accusation. There is also, because Phoenix was suicidal at one point, she doesn't have a door on her bedroom because we had to watch her closely. For 2 weeks, she was on suicide watch before she went into the institution.
Mhm.
And so there's a camera directly on that bed alone. She has privacy everywhere else.
So how many children in the household that are underage?
For-
And those are the 3 children that you took into your home?
Yes.
All right, and how many adults are in the household? All right, and who are the 5 adults?
My son, he's 30 years old. He is upstairs with the girls when they come out of the gate. His bedroom's right there.
Okay,
My father-in-law sleeps on the other end where the children's playroom and TV room is.
okay,
And David's mother, who is downstairs at the very front of the house,
okay.
and then me and David.
All right, any other questions?
Yes, Ms. King, the 2 younger children, they're nonverbal, is that correct?
Oh, no, they're not nonverbal. They're very verbal. They're very high functioning.
I functioning.
Yes.
No further questions.
Yes.
Just for clarification, Phoenix did go into inpatient care for how long?
She was in for 7 months this last time at Cedar Crest Hospital.
Okay, and so if she gave any indication whether this did or didn't happen to them as
Yes.
well, you weren't around.
I wasn't there.
And lastly, the state says that David was arrested on in 2024. It was actually March 19th of 2025. Is that correct?
That's right.
Okay. That's all, just for.
All right,
That was the other person.
and other than this child, have any of the other children accused him?
Accused him? No, Your Honor.
They
But
accused her.
they are verbal and they accused Phoenix
While
of
she
acting
was
out.
institutionalized.
Okay,
And she knows that she did it. She will tell you.
okay. All right, so if y'all can have the caseworker zoom in, the court will make its ruling.
Thank you, Your Honor, very much for your consideration.
Sure, you're welcome. And if you talk to Norma, once you have the number, she'll give you the Zoom link. Anyone else ready?
Girlfriend Jeffrey Smith, page 95 down.
Okay, we'll keep an eye out for the return of that party. Let's go back to Judge Stevens.
Giving you that. Jeremy?
I need a fingerprint. Please.
It means up there, people every day.
That's it's just third one. Tom says it was dismissed.
Are you sure you're business?
Oh, you had it all the time, yeah.
Mr. Roberts, I need you to step up here.
Over here. Thank you. Thanks, Jeremy.
It's your right hand, you swear one from jail. Your right hand, Chris. I need it. She doesn't know how to.
That was gonna be a problem.
I don't know yet. I have to.
21-38145 is called Jeremy Joshua Roberts. That's you, sir. Present with Mr. Burbank, you attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment? Can we proceed in summary?
He does, you Mayor.
In summary, this indictment alleges that on or about July 24th, 2021 in Jefferson County, Texas, you committed the second-degree felony of aggravated assault. Do you understand what you're charged with here, sir?
Yes, sir.
You've not been in trouble before, have you, Judge? Now this is fixable. Fixable. Let's move on with your lives. Just everybody makes a mistake from time to time. It's just how you fix it.
Okay.
A second-degree felony means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement has been reached in your case. You would be pleading guilty, placed on deferred or unadjudicated probation. Is this 400?
400.
Fine of $400. That's odd.
Yes, and you just said.
It isn't a 4 that I recognize in the
400.
Arabic numbering system that we've used for years.
We asked that, that for probation, just for the license.
And there would be terms and conditions of probation which are normal and customary for this service. It can be up to 10 years in length. Do you understand this? If I follow this agreement, you have no right of appeal of your case. Do you understand? How do you plead to this, guilty or not guilty?
Guilty, sir.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty?
Yes, sir.
We got a problem in there. You're gonna get some more. We're gonna have a problem.
There's two back there already now, Judge.
All right. To show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea.
Yes, sir.
It's freely and voluntarily. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report as well.
Yes, if you will.
I'm going to follow this agreement.
We would ask for consideration of less than 10. We know that's too difficult to support. He does not have a record.
And huh? All right, this, okay, I'm reading this, and according to this, it states that the defendant, there was some kind of a problem. there's a security guard arguing with the defendant at a lounge.
It was at a.
Hold on, let me read this and y'all can, the defendant pulls gun out, points it at the complainant, pulls the trigger, the gun malfunctioned. And so the difference between murder and what we have here is a malfunctioning gun.
Well, that's kind of the contention we have. It's not that he didn't pull the gun out, which is basic to, germane to the charge, Judge. It's whether or not it was actually, trigger was pulled. But,
Yeah, but that's what's in the indictment.
well, that was in the indictment, but.
It says pulling the trigger and then in there using exhibit, well, is he guilty or not?
Yes, he's
Okay.
guilty of.
Well, it's gonna be 10. I mean, let's just thank God that there wasn't a murder. And when you pull a gun out and point it, I mean, the complainant can only think one thing. His life is the end of his life is a clock's tick away. But could have been worse.
Yes, sir.
I find that there is sufficient evidence supporting this guilty plea to find you guilty beyond a reasonable doubt, but I'm going to defer any finding of guilt. Place you on deferred or unadjudicated probation for 10 years. You do well, it'll be shortened at 3 1/8, and you will not have a conviction. There will be terms and conditions of probation, which are normal and customary for this type of offense. Please make sure you follow them. There's a fine of, was it 400 on it?
Yes, Your Honor. This
Fine
is
of,
one other thing.
oh, this says 500, but y'all said 4, right? It was kind of, I looked at it and it was weird, but it's showing 4.
Need you 400, do it.
4.
Okay, yeah, but that's, okay, that should push the 6. Okay.
That's an odd number, but that's what it was showing.
Yes, sir.
But then again, there's a lot odd going on in this room, you know, so we are not conventional.
It's a strange one.
This is not a conventional room.
Mr. Robertson is also requesting, Judge, I think now that he can have his ankle monitor removed.
Yeah.
Because he's out.
Sure. Yes. Okay, great. That's kind of an inconvenience to say the least, isn't it? You get used to it like a friend, but then again, it's time to part.
Yes.
There comes a time when it's time to part.
It would be excused.
Yes.
Yeah.
Yolanda Martin? We'll wait until he does. He's in custody until he does. Okay. That's applicable in all cases. Yolanda Martin, please, on John West. Where's John?
Judge, man had to run to another court.
John.
Taking care of, yeah, I see. William there's taking care of John. Okay, hold on, man. We'll wait until he gets here. Okay, thank you. Justin Barry, Brian. Oh, it's Brian. It's Kevin.
Yes.
You doing Brian stuff?
Yes, Your Honor.
Here, Judge.
Thanks, Justin. Okay.
Yeah.
You know, they did 3.
Yes, Your Honor.
All 3. It's all 3. Let's do it numerically. Does the defendant waive formal readings of these indictments and arraignments? Can we proceed in summary?
We can, Your Honor.
In summary, 23C or 1437, sir, states, and you were Justin Keith Berry. Here with Mr. Lane, your attorney and the state's attorney.
And Your Honor, just for that point, I'm standing in for my brother, Ryan Lane, with the consent of Mr. Perry, is that correct? Yes, sir.
You're still a licensed attorney.
I am. 29 years.
Yeah, and you don't object to Kevin being here on behalf of Brian Lane, Kevin. Very good lawyers. All right, in summary, this indictment alleges that on or about April 2023 in Jefferson County, Texas, you committed a third-degree felony of theft of property involving more than $30,000 and less than $150,000. It's like a GMC automobile. Do you understand what you're charged with here, sir?
Yes, sir. Yes, Your Honor. It was a U-Haul, I believe, so that's the.
If convicted of a third-degree felony, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. All the smudges go on. Can't touch this thing.
Yeah, sorry.
That's why I use this thing to prevent my palm. An agreement's been reached where you'd be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. Restitution is ordered in the amount of $1,500. There will be terms and conditions of probation normally customary for this type of offense. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
We now go to 24 COS 5-4. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
He does, Your Honor.
In summary, this indictment alleges that on or about July 6, 2023 in Jefferson County, Texas, you committed the first-degree felony of illegal possession of methamphetamine. You understand what you're charged with here?
Yes, Your Honor.
First-degree felony means you were facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this indictment, guilty or not guilty?
Guilty, Your Honor.
Are you pleading guilty voluntarily and because you are guilty?
Yes, Your Honor. I'm not saying that it's her act, so, you know, she's pretty adamant. But, you know, they're not. You do some to understand, but you are, no, I'm not saying something. I'm gonna do that.
Finally, 24 CR 55 is called State of Texas versus Justin Berry. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does, Your Honor.
In summary, this indictment alleges on or about July 6, 2023 in Jefferson County, Texas, you committed a first-degree felony because of possession of a controlled substance, namely cocaine. Do you understand what you're charged with here?
Yes, sir.
Same punishment range as before. First-degree felony applies. That means you are facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, Your Honor. All right.
Agreement's been reached in your case. You would be pleaded based on deferred or unadjudicated probation for up to 10 years in length. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal.
Yes, sir.
How do you plead to this case, guilty or not guilty?
Guilty, Your
Are
Honor.
you pleading guilty voluntarily and because you are guilty?
Yes, Your Honor.
In each of these cases, I show you what's marked as State's Exhibit 1. Did you sign those documents voluntarily, understand them, discuss them with your attorney, or the contents all true, correct?
Correct, Your Honor.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted in each case. This states you are mentally competent to enter your guilty pleas in each of these cases, which are freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, read them. You were guilty of the crimes charged and any lesser included offenses. You were giving up your rights to your jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the help that your attorney has provided to you in each of these cases. All of this is true, say, so help you God.
Yes, Your Honor.
State's Exhibit 1, made a part of the record in each case. Pre-sentence reports waived in each of these cases.
It is, Your Honor.
I'm going to follow these agreements if nothing further and find in each of these 3 cases, sir, you have pleaded guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty pleas from State's Exhibit 1 admitted in each of these cases to find you guilty beyond a reasonable doubt. But I'm not going to find you guilty. I'm going to follow this agreement. I'm going to defer any finding of guilt so long as you follow these terms and conditions of probation. You will be placed on deferred unadjudicated probation for 10 years in each of these cases to run concurrent.
Yes, sir.
On one of these, you're going to, as to one, you must complete a theft prevention class, which is always required in that type of offense. Involving theft. There will be moral reclamation therapy also, which are all short programs, which are good and help you make the right decisions. Make sure you follow these. Conditions of probation. If you fail, your probation could be revoked. You could even be found guilty and sentenced up to the full range of punishment as it will be. So
Yes, sir.
you'll do fine. But fix this.
Yes, sir.
He had a vote, make sure they don't see him there.
Thank you.
Thank you. Thank you.
You're welcome. Good luck, sir.
All right, let's stay in the building, but we'll go over to Judge West, where she typically has her Monday fashion show.
Good morning. Are you Drayden Rose? And Mr. Rose, this is your initial appearance in cause number 25 DCCR 0789. You're charged with the 3rd-degree felony offense of assault of a security officer from April 16th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? How old are you?
18.
Are you still in school?
I got my GED.
You got your GED? So are you working?
I'm finding a job.
So you don't just get a court-appointed attorney. So what I'm going to do, since you made bond, I'm going to reset your case for about 30 days and do a couple things. One, you need to try to get a job first. If you get a job, bring me that information on where you're working, some kind of pay stub or just something that shows where you're working. I also want you to apply for at least 5 jobs a week. And if you don't have a job, you need to bring me where you've applied. So if you're print something out or copy something from where you've gone. And then in addition to all of that, I want you to start talking to attorneys, okay? You need to talk to at least 3. They all charge different amounts. They have different payment plans. I want you to start talking to them so that when you get a job, you can see maybe what you can afford or what you can't. If you do all that and you still can't afford an attorney, then we'll talk at the appropriate time about a court appointed. If you don't do those things that I asked you to do, then when you come back, you run the risk of erasing your bond and you would have to go back to jail for not following that court order. Do you understand all that? All right, if you'll step in front of the clerk, she'll give you a reset notice. Lance Charbino. Good morning. You're Lance Charbino?
Yes, ma'am.
And Mr. Charbino, did you get someone hired?
I did not hire him yet. It's Cody Crenshaw.
Corey?
Well, Corey is. Corey
Uh-huh.
Crenshaw. He asked for $4,000 down.
Okay.
And as soon as I get that, which should be about 3 weeks from now.
Okay.
And I'll be able to get him hired for.
All right, you've been here a few times, so I'm gonna reset you one more time. You need to get him or someone else hired before that next court date. Again, just bring that reset notice to him. He'll tell you what to do. If it's not gonna work out with Mr. Crenshaw for some reason, then talk to at least 3 others. Bring me those names. All right, step in front of the clerk. She'll give you a reset notice. Presley Viltz. Good morning, you're Presley Viltz. Did you get someone hired, Mr. Viltz? No? Who'd you talk to? Okay, did you write down the names? Well, no, I mean, I tell you the same thing I tell everybody. Bring me back the names of the people you talked to so that I know you've tried, and then we'll discuss your options. Same words I've said for 11 years to every single person in here, so no one can ever say that I didn't say them. So what part of bring me back the names of who you've talked to did you not understand? You just forgot. Okay, so you're in felony court. You don't just forget, because if you don't do what I asked you to, then I can put you in jail right now. I'm trying not to do that. I want you to follow the rules. It's not that hard. You have 30 days. Talk to 3 lawyers. Try to hire them. Did you talk to 3? You really talked to, so when you first answered, you said you talked to 2. So be careful what you're saying. All right? And you're probably nervous right now, and I get that, but be careful what you're saying, because you're saying some different things. I'm going to reset your case for 2 weeks. You need to talk to 3 lawyers. You need to bring me those names of who you talked to when you come back. If you've hired one of them by then, great. If not, I want you talking to at least 3. Don't wait till the last minute, because they're in court and they have things to do. So start calling today, talk to those attorneys, bring me back who they are, how much they charge. Let me know about where you're working, bring a pay stub when you come back. The more information you bring me, the better things are gonna go. Does that make sense? All right, 2 weeks, step in front of the clerk. Caitlin Talmore. Good morning, you're Caitlin Talmore? And Ms. Talmore, this is your initial appearance in cause number 25, DCCR 0595. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle, and that is from April 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right, so what happens is when you're in custody in jail, we automatically give you a court-appointed attorney. Now that you've made bond, I'm going to expect you to at least try to hire your own. So what I'll do is reset your case for about 30 days to give you some time to try to hire somebody. If you do get someone hired before the next court date, bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to go visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of those you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond, and you would have to go back to jail. Do you understand? Yes. All right, step in front of the clerk, she'll give you your reset notice.
Fine.
Janisha Leonard. Good morning, you're Janisha Leonard? Let's see, and Ms. Leonard, you have 2 motions to revoke your probation, and then you have a new case in cause number 25 DCCR 0297. And set bonds and you've made bonds on all of those. And have you had an opportunity to hire a lawyer? Okay, so you need to get someone hired. The fact that I set those bonds at what I did, even when the state asked me not to, you've got some serious stuff going on. You need to try to get someone hired if you can before that next court date. So I'm gonna reset your case for 30 days. You need to try to get someone hired. If you do, bring the reset notice to them. They'll tell you what to do. Go ahead. Well, you need to try to get a job first. And you need to apply to at least 5 jobs a week, and you need to bring me proof of that. Okay, if you do get a job, bring me some proof that you have a job. In the meantime, I'll also want you talking to lawyers. Bring me back the names of the lawyers you've talked to, at least 3, so I know you're trying. Bring me the information about that you're trying to get a job, and then we'll discuss all of your options. Okay, if you don't do that, then your bonds will be raised, especially on those motion to revoke probations. You'll be right back in jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. How'd you make all those bonds?
My family came together.
Okay, well, you might need to get with them on this too.
Yes, ma'am.
Okay.
Relatively tame morning for the typical Judge West Monday, but I'll keep an eye on it. Let's go to Louisiana. There's a big group of people. Let's see how this goes.
Introduce yourself. Tell us your name and DOC number.
My name is Dwayne Middleton. My DOC number is 116831.
All right, Mr. Middleton. We have some folks there with you at Angola. Let me introduce those folks. You have Ron Hicks, Cheryl Banks, Anthony Brown. I'm sorry, Anthony Brown is here. Okay. Lakeedom Johnson, Jennifer Brown, and Letha Middleton. Here with us in Baton Rouge, we have, is it Mr. Garrett Middleton? Right. Tony Middleton. On Zoom, we have your attorney, Mr. Jones. I'll ask for him to introduce himself in a moment. And we also have the Parole Project, Mr. Blake. Mr. Jones, would you introduce yourself for the record, please, sir?
Yes. Good morning, Ms. Renata and members of the board. I'm Charles Jones, an attorney in Monroe, Louisiana. I represent Mr. Dwayne Middleton, and I apologize to the board. I was in court, but I represent him this morning on behalf of him and his presentation before the Board of Parties.
Yes, sir. Thank you. And we'll hear from you just in a minute. Also here with us in Baton Rouge in opposition, we have the victim, Ms. Tara Nguyen, and Mr. Philip Nguyen, her husband, and they'll both be speaking at the appropriate time. We'll ask them to do so. First, I'm going to read some identifying information into the record, Mr. Middleton. Mr. Middleton, you are seeking a commutation of sentence. You were sentenced in Ouachita Parish in February 1987. First degree robbery, you received a 40-year sentence. For aggravated kidnapping, you received a life sentence. And first degree rape, you received a life sentence. Is that information correct, sir?
That's correct.
All right. So, Mr. Middleton, the first thing we'd like to do is hear your statement. Tell us what landed you in prison and why do you think we ought to vote favorably for you today?
Well, what landed me in prison was that at that time, I wasn't a bad person at that time, but I smoked marijuana, but I wasn't a regular marijuana smoker. I probably smoked marijuana. Maybe some weeks may pass by. Same thing about alcohol. But the night of the crime, my biggest mistake was I smoked a drug that I never smoked before with some of my friends of mine. That was PCP. And after I smoked that PCP, I wasn't the same person. I never would have committed rape in my right mind. And I'm very, very sorry about that. And I apologize to the victim. I'm sorry that I put her through the trauma that she went through. And so I asked that the victim to forgive me for that because I was wrong. And I asked the board to give me for it also in the state of Louisiana. Now, since I came to Angola, I came here, I was 25 years old. And when I came to Angola, and as soon as I got off the bus, I started running because I seen the ignorance in Angola. Now, I was back and forth from college when I was on the street. So I did everything that I can do to help people since I've been in this prison. I was an ordained pastor. I took all the programs most of the programs that's here in Angola. So I've been preaching, I've been teaching the word of God for over 30 years. I volunteered in the hospitals with the patients, with their families, cutting people hair, bathing, whatever I can do. I went in the areas of the prison. I've been cell block ministry in this prison for over 20 years. And people don't like to go to cell block, but I have been doing it. In my ministry, and not only preaching the gospel, but yard ministries and whatever I could do to help. I've been trying to do that since I've been in this prison. And I've been doing it, and I've been trying to help people, whatever they do, whatever they need, or whatever they do, I'm there for them. With the chaplain staff or whoever it is, and I got a relationship with the security officer. I'm very sorry about the crime that I committed. I was wrong.
All right, and I failed to mention that we do have some folks also here in support of the victims. We have Wesley Ho, Corey Williamson, Ben Hartman, Amy Sulte, I'm sorry if I mispronounced that, Jessica Perry, Susie Johnson, Tammy Fetzner, Danny Dayton, Helen Foschultz, Sean Siebold, Melissa Mansell, Cherie Rundles, Elizabeth Mitchell, Will Beatrice, and Todd Newman. I apologize, I didn't read that into the record sooner. Warden, what can you tell us about Mr. Middleton?
Mr. Middleton is medium custody. He's assigned to D Eagle 4 and works in a library. He has a total of 13 DBs, his last report being 11/24/20 for Rule 30W. Programs he have taken is 100-hour pre-release, anger management, substance abuse, thinking for change, the 3 phases of sex offender treatment, IC3, which is digital literacy, and his Tiger is low.
All right, thank you. And
he also has a third stage certificate.
Oh, okay, thank you.
You're welcome.
We'd like to hear from those who want to speak in support before we turn it over to Mr. Jones. So could we please hear from Letha Middleton, who's there at Angola?
Okay. I just speak? Yes. Hi, my name is Letha Middleton. I'm Dwayne's sister. I have been backwards and forth here coming here for almost 40 years. He has been a changed man, 160. We were both young when he came here. He's a year older than me. He has been a mentor to me, a mentor to my kids. We come up here. He has been an absolute great brother, a great uncle. He has did all these things in prison to turn his life around, and I see the change in him, and that's a blessing from God. And I am, I can't imagine what the victim went through, but every day that crosses my mind. But he is a changed person and a good person, and I just, come to you with a humble heart that you would grant him a pardon. Thank you.
Yes, ma'am. Thank you for your support for almost 40 years. Thank you so much.
Right.
Here with us, we have Mr. Tony Middleton. Mr. Middleton, would you step up to the podium and tell us what you'd like us to know? You need to address your remarks to us. Turn around. Yes. Yes.
Stay
behind us. Thank you.
Right here.
Behind the podium.
My name is Tony Middleton, this brother Dwayne Middleton. And I've been supporting democracy being here. He's a very good guy. It just changed his life and his sanity secure. It was drugs, a dangerous drug that was on the streets. And this drug is very dangerous. It had hallucinations and all that. He just got over a bad drug. He's never done anything to say he was a menace to society, anything. The time and place. That's all I can say. That's all that I can say about it. I know it is right mind, you'll never be able. Thank you.
Yes, sir. Thank you for being here. And the parole project, Mr. Blake?
Good morning to this honorable board. Channing Blake with Louisiana Parole Project, appearing on behalf of Mr. Dwayne Middleton. He's an ordained minister. He's been the president of various organizations. Because of his volunteering with hospitals and his programming, we have accepted him into the Louisiana Parole Project. Should the board give him a favorable recommendation today, we will provide him transitional housing, employment assistance, and substance abuse evaluations. He will also be assigned a reentry specialist that's going to guide him through his reentry process. Based upon his record, his rehabilitation, and his strong support system, we ask that you grant him a favorable recommendation today. Thank you.
Thank you. All right, Mr. Jones, we'd like to hear from you, sir. I'm sorry, sir, you're muted still?
Okay, all right, thank you. Can you hear me now?
Yes, sir.
Okay. Good morning, Chairwoman Renasa and members of the Louisiana Board of Pardons. I'm Charles Jones, and I'm here to represent Mr. Dwayne Middleton. I was very much surprised this near 40 years ago when I heard that Dwayne Middleton had been arrested. I had seen him and had was very much surprised. I was not connected to him on a personal basis, but I knew of him, and I was very much surprised when I heard that he had been arrested and subsequently convicted. As has been said, Dwayne, as I appreciated, is 38 years has been in prison, and I think in the next 2 days or so, he'll be 39 years, I think. He was, as has been said previously, he was on it was found he was on drugs, and I've known a number of persons over these 50 years that I have been practicing that once they are addicted to drugs, particularly the PCP, it changes who they are. They are not the same persons that they were before. And so he has indicated that he is very sorry about what he had done, and I believe that. His mother's deceased, his sister's deceased. Dwayne had no previous, as I remember, had no previous conviction before this conviction. As has been stated before, I have talked to him on numerous occasions regarding his ministry, and I know what that does for you, having been a minister and being a minister myself, that he had no previous convictions, that he has been a minister for 30 years. And the fact that he's been a minister for 30 years, I know that oftentimes one of the things that people say is, well, once you go to jail, everybody becomes a minister. That is not the case. And your calling is not from men in the first place. Your calling is from Almighty God. He has certificates, and I know these matters have been submitted to the board, the certificates of training and inmate training and other certificates that you are in receipt of. It's my understanding there are some certificates by former clerk of court of East Baton Rouge Parish, Doug Welburn. he has a license under the Rock Word Evangelist Ministry. He has not had very many write-ups. It's my understanding that he has not had a write-up in the last 5 years. But one of the things that I find that is most impressive to me is that he is remorseful, he is repentant, and he is rehabilitated. And I'd like to say to this pardon board that if anybody in my mind who deserves an opportunity for change, and he has changed, an opportunity to be able to contribute to society and make a difference in society is Dwayne Middleton. And so I would like to ask this board of pardons, ask you all to grant him a pardon of the relief that he is asking, and that I'm going to ask the board to do that, because you will not be disappointed. I believe that Dwayne Middleton has the kind of spirit and is the kind of person that if he is granted the pardon, that he will not disappoint this board, and he will not repeat the action and the that landed him in prison. For him to administer and to be the kind of minister that he is in Angola speaks for itself. I have known and represented a lot of people who were in Angola, but Dwayne Middleton is truly a minister, and he is, as I've just said, he is remorseful, he is repentant, and he is rehabilitated. He has said that he is, of course, remorseful for his action and repents for his action. And I believe that this Milton family, if you were to know them as to who they are, that he was representative of who they are and who they are today, but for this drug addiction that he unfortunately ended up with. So I'd like to ask you to grant him the pardon, give him the opportunity to be who God has called him to be, and you will not regret it.
Thank you, sir. Thank you. We appreciate it. All right. At this time, we'll hear from opposition. So, Mr. and Mrs. Nguyen, I'll let you decide who would like to speak first.
Stand before you today as an older woman, but as an 18-year-old freshman on first day of college. I was kidnapped, driven to a remote wooded area, threatened with my life, and brutally raped. This event changed my life forever. I firmly believe this was not the first time this crime had been committed. It was far too easy for this predator to find a remote location with no apprehension, no hesitation, and no remorse. I was terrified and feared for my life. The impacts I have been profound and continue today. PTSD has ruled 3/4 of my life, always looking over my shoulder, isolation, hypervigilance, night terrors, flashbacks, self-destructive behavior, distrust, depression, and anxiety remain, and I remain on medication for this to this day. Sexually, intimacy has continued to be uneasy and awkward. the inability to have children, overall fear of having sex, the inability to show affection only to those very close to me received it. Relationships with my family deteriorated, changing the dynamic, particularly with my father, whom I didn't allow to touch me, either through hugs or even high fives. Family members in my community offered no support due to the stigma of rape. Friends whom I've known throughout my childhood were no longer. I was alone to hear and endure the rumors, the lies, the blame, and the judgment. Education was robbed from me, missed opportunities, desperately wanting to feel like a normal college student. Anxiety prevented me from pressing forward. Struggles attending class. Focus was difficult, taking me several years to graduate. My self-esteem had crumbled, leaving me to feel unpurposeful and unworthy even today. Frankly, I'm a bit angry that this rapist has asked for freedom, as I've never had freedom. The goal should be safety to society, not just punishment, and not just taking care of the victims. This rapist was given 2 life sentences plus 40 years for a reason. Once a rapist, always a rapist. Thank you.
So when I am Sarah's husband of 19 years, everything that she has been through is part of my life. It is the most painful thing as a husband to not be able to get that pain away from me. So, I mean, I'm trying to talk about rehabilitation stuff, but what I hear is a wolf in sheep's clothing. Because let's get real. This is a man that raped an 18-year-old child, right? This is something that is primitive. This is instinctive. This is animalistic. I see this when I went to war. I see the wolf that's hiding in the sheep clothing. All right. So my question is, if we want to talk about justice, where's the justice and giving him clemency when Tara is having to live this every single day of her life? Where is the justice in handing him this clemency when I am also affected as a person? Because let's be realistic too. He took away our ability to have a family, to have a child. So where's the justice in handing clemency when all that resonates in our community and in society that it's okay to rape an 18-year-old child? Screw that. All I have to say.
Thank you so much. Mr. Middleton, your case was assigned to Mrs. Stapleton. Would you answer her question?
Yes,
I'm going to start off before I speak to you and saying to the survivor who was victimized, I know that it took a lot of courage to come here today. And I want to congratulate you and your husband on being able to do this. Okay, so here's where we're at. I've been hearing, I mean, we've heard the details of the crime already. We've heard it from the victim, the person who has been living with this also. Her consequences for something she didn't ask for and something she couldn't prevent. But it was over and over that it was PCP that caused you to do that. So it was at 3 a.m. that morning that you did it. And then you looked, then, you know, she was left, she was free. But by 11 a.m., you had the wherewithal to go into one pawn shop. You stole things from her and you pawned a 14 karat yellow gold nugget ring. Police were told about that. Then you went to another pawn shop and you pawned several items. And you pawned a 14 karat gold emerald ring. So where'd you get the wherewithal to come to yourself so quickly after PCP to be able to have the items that you stole from this young lady and then sell it so that you could reap the benefits? I mean,
Well,
went away that quick?
Well, it was the first time I did PCP. I didn't know the strength of the drug, and so it did wear down. But it goes to show you that to take the jury and to sell the jury, it showed that I was not a career criminal. A career criminal wouldn't do a thing like that. That he would take jury, something he stole from someone after committed a crime, and then go pawn it. He'd be trying to hide his identity in some type of way. But I was on PCP. It was a drug that I had never messed with before, and that's what did it to me. And I wasn't a drug user, and I wasn't I didn't really have habit with drugs. It was something that I used at the spur of the moment with some friends out that night, and it caused me to be a different person. In my right mind, that never would have happened to Tara Crowley or no other woman that night. And it wasn't a crime where she was stalked or followed or anything like that. It could have been anybody with the drug that I was on. I was completely out of my mind with no control. And for that, I am very, very sorry.
It's amazing that that's how you decided to express yourself on that drug. But I do want to mention at the pawn shop, they said that they recognized you because you had been there several times before in the past. So it wasn't something that you did for the first time. It was something you knew to do. You knew how to pawn stuff, how to go get money for it.
Yes, ma'am. I was in and out in jobs and things like that. I was doing the best I could as a 20-year-old. And sometimes when I had things to pawn to make money, I would do that. And that pawn shop that you talking about was my favorite pawn shop. Me and that guy, we had a relationship for his pawning. But there were sometimes, it was hard times, might have to pawn something to make it. And I did.
Well, what were you doing with your life at that time? She was going to college. She was trying to start life right direction. What were you doing?
At that time, I was re-enrolling back in the Grambling. I was a college student myself. I was in and out of college. Sometimes I would drop out, I'd get a job. At that time, during that time, I was a substitute teacher for the parish school board.
Wow. Okay. When she was in college, I had read that for her to go to school, that her sorority sisters loved her so much that they would take her back and forth to classes and would make sure she felt safe from that point on, because she didn't feel safe at all in life. And here we fast forward to all of this, and we hear the same thing is going on. And that's not unusual. The things that Miss Crowley said, I know she's married now, is what we hear. And the tears is what we hear. 20 years down the road, there's consequences for this crime. And your consequences, did you have a jury trial, by the way, or was this a judge's?
It was a jury trial.
So a jury decided that you were to get 2 life sentences plus 40 years. So for us to do any different would be for me personally, as a victim's advocate, and to just thumb my nose up to a decision that was made by them with great thought and deliberation also. And here we find ourselves today, and I know that she was told without possibility of probation, pardon, or parole, or, diminution of sentence. But that's not true. That's not what happened. So for a victim, when this kind of thing happens, they relive a trial over and over and over again also. You relive it on your side but they relive it on their side. And then they have to relive the circumstances. So there never is a chance that they do get able to walk out of a courthouse, like I've heard victims say, and say, I'm never going to think about this again. So they become survivors, but they're survivors that was victimized by horrific crimes. I read when I saw your needs assessment, it showed you having antisocial skills. It showed it very high, and substance abuse very high, and mental health was medium. So that's what they showed for now. Did you get any mental health assistance there?
I went through the sex training programs that they offered here at Angola. Phase 4 went to phase 5, but didn't complete it because so I think something happened with one of the instructors at that time. And but I've been getting my rehabilitation through going to church and other things like that. And I want to say that it was terrible what happened. I can understand what the victim is going through. And
No.
I'm very, very
I hate to tell you, but no, you can't. You're getting some consequences, but you cannot understand what you went through. You know, you can feel bad about what you did, but no, you can't. You can't put yourself in her.
But while I was saying that, my older sister got raped when she was 15 years old.
Yeah.
And she went through some of the similar things that she's going through now. And our family, we had to also comfort her in the same thing that the victim is going through now. So it's not that we don't know about that, because we does.
I understand. Well, you've got extreme law enforcement opposition, and you know that you have extreme victim opposition. And so I'm finished with everything I need to say.
All right, any other questions? I see no other questions. I believe the board is prepared to vote. Mrs. Stapleton?
Mr. Middleton, I'm going to deny your request for a commutation of sentence. You were sentenced to 2 life sentences plus 40 years by a jury. I also have strong all community attitude is opposed, which is law enforcement and victims opposition. And the crime was heinous.
Mr. Prater?
I concur, deny victim opposition and the seriousness of the crime.
Mr. Freeman?
Deny victim opposition and law enforcement opposition.
And Mr. Tillis?
I vote to deny also.
All right, Mr. Middleton, you've received 4 votes to deny your application. So today your application for clemency has been denied. Good luck to you, sir. Continue doing the work that you're doing there at Angola, helping others. Good luck.
Okay, thank you very much.
Denied.
To the shock of no one, that is as it should be, quite frankly. If he has found God, I, as a person of faith, am thankful for that. However, the big thing for me in that one was he kept saying, you know, well, I did this drug. Well, you made the choice to do the drug. So even if it was the drug, you still own everything that happened from that point forward. And it was bad things, and bad things have bad consequences. That's all I'm saying. Let's go back to Judge Boyd, that case we were following earlier. The guy is approaching again.
The state has informed the court that the caseworker on the CPS case and the supervisor are no longer employed with CPS. All right, I'll hear argument.
Hi, yes, Your Honor. So the reason the state is asking for the no contact order, one, because in cases like this, these are bond conditions that are typically put in place. That was not put in place. The defendant was arrested out of county and then bonded out. So whoever magistrated in out of county did not put any conditions on. My understanding is that from reviewing the CPS records, yes, CPS did allow the defendant back in the home after these allegations came out, and also after they found reason to believe. And to me, that just does not seem reasonable. And so that is why the state is asking for the no contact order, because the child has been in the home with the defendant and with her mom, for all intents and purposes. who, she's been in the home this entire time with the defendant who she says that has abused her, and the state cannot adequately analyze their case while the child is still in the home with the defendant.
All right.
Your Honor, if I may please the court. This case, the allegation happened in 2022. The officer did state that he had gathered all the information as he saw fit, but was going to turn it over to the DA, even though the alleged complainant recanted. This case wasn't picked up until March 2025, where CPS had already allowed my client back in the home, and there has been no indication of anything going on since 2023. It has been status quo. He also bonded out on a $100,000 bond from the state's investigation, or from their investigator, which kind of charged him incorrectly. I believe his bond is overly intrusive. I would hate for his bond to be reduced and him to have to rebond out to go through the process, because he's already spent everything he had on the $100,000 bond. They have adequate cameras put in place. Everything has been status quo since. You've heard a very small portion of why the children need supervision at home, also David's supervision at home. He has cameras in all the right places that need be. There are other individuals in the house as well, and I just think it would be overburdensome for my client to have additional conditions that weren't put on until August of 2025, when the state is finally getting ready for this case. We've been ready, well, since March. I'm asking that the bonds remain in effect the way they are until trial, and we'll be ready.
All right. So this is what the court will note for the record. The indictment, and both parties have agreed that the indictment is incorrect, that he does not have a prior conviction. Is that correct?
Yes, Your Honor.
And then the court will note that he's been in the household for this length of time. Both parties have agreed that the witness has recanted. Here's my question for you, because I still, CPS does their investigation. Their investigation is their investigation. I know that you've been in the house for the length of time that you've been in the house. I know that you have cameras up. Question for the court is, will you make those cameras accessible to the DA?
Most definitely, Your Honor.
All right. So if he's going to make sure that the cameras are accessible to you, my understanding, it's an SD card in all of the cameras.
Yes.
All right. How often are you going to want to view the SD card?
Your Honor, I guess it's something I can work out with.
All right. If y'all discuss that, but I'm not going to order the no contact order based upon everything, the evidence that the court has heard based upon the indictment being incorrect. If the indictment were correct, this would be easy for the court to make a decision on.
May I ask my client one question?
Sure.
Off the record. Your Honor, it's my understanding that these SD cards record for 30 days. I would say.
Do they ever, is there any recording over?
No, I was going to say, can we get a double and have them available for the state?
If you all will discuss that, how often you want those available, but I'm not going to grant the request for the no contact order based upon the evidence that I'm hearing. But I am going to add the condition that the state is allowed to view the SD cards. And if you all can just come back to me and you all can write it in the order, how often you want those SD cards to be reviewed by you. All right. So will they be able to turn over the SD cards?
I will have my client buy additional SD cards and then provide them to me, and I will have them available for the state. And then I guess when we give them the next ones, they'll give us those back.
All right, so we're at the end of the month now. So I'm going to want an SD card provided to them before this month is out. And then after today, let me see. So that will, when will you be able to provide that to them? Friday?
Your Honor, I'm stepping into something I don't know. What I'm wondering is if I could provide like a 2 terabyte card and all these SD cards be loaded That way, the same cards can be used and I can constantly have those.
Sure. But my understanding though is, are you going to be able to provide it to them at the end of this month?
I'll take care of that.
All right.
I will
So,
get more SD cards, and my outdoor cameras have a home base, so it has a 2 terabyte hard drive in it. If you have access to plugging it, I'll take the hard drive out and review it, and then I can put it back in.
all right. So, we'll begin with the first date, the end of this week, and then 30 days thereafter.
Yes,
All right. Is there anything else?
not from the state judge.
Nothing from the French, Your Honor. Thank you
And
for
let
your
me see,
consideration.
does he already? Yes, he's coming back. All right. If there's nothing else, then you will be excused. And thank you for addressing the appropriate court. I'll sign this order and then you will have it.
Thank you, Judge, very much for your
You're welcome.
consideration.
Thank you.
All right, now we know how that ended. Let's go back to Judge Stevens.
You got it.
Yolanda Martin.
Thank you. 3341301 is called Yolanda Adams Martin. That's you, ma'am. Present with Mr. West, your attorney, and the state's attorney does the defendant waive a formal reading of this. Good Lord. Indictment and arraignment. Can we proceed in summary?
We can, Your Honor.
In summary, this indictment alleges that Yolanda Adams Martin, also known as Yolanda Lynette Martin, also known as Yolanda Martin, also known as Yolanda Adams, also known as Yolanda Lynette White, and finally also known as Yolanda Lynette Adams, on or about October 6, 2022 in Jefferson County, Texas, you committed the state jail felony of theft. That's what's alleged in paragraph 1. Paragraph 2 goes on to allege
And we just need the first two, Your Honor, of that.
that you've been convicted before of thefts out of county courts of law, criminal district courts, felonies, and misdemeanors. You know how many, this is your life, you should know, how many theft convictions do you have now?
I don't know.
What does it say about you that you don't even know? What do you think? Give it a guess.
10?
16. 16 convictions in felonies and misdemeanors. So when you steal a pack of gum, it's a felony. The rest of your life, automatically. Do you understand? Okay. Yeah, and I'm looking at 16 convictions here in paragraph 2, 1988, County Court of Law 2, 1999, 92, 92, 93, 94, 96, 99, 2003, 2007, 10, and rounding out 2013. Your attorney has gone over all of this with you? Yes? Yes. Okay. Paragraphs 1 and 2 constitute a state jail felony. So that means that you're facing no less than 180 days up to 2 years in the state jail and a fine not to exceed $10,000. What's this?
Class A misdemeanor.
With 16 convictions?
Can we talk to your attorney and always make her, because you told us to do that. We got something special to talk to you about.
Well, Judge is muted. Earlier, Carissa gave 5 gift memberships, and I don't know if I acknowledged that verbally. I know I did in the chat, but thank you, Carissa, for that. And Barbara just threw down another one, plus 1 earlier, plus I think 2 before that. So thank you for those. Very much appreciated. Also, since I haven't really shouted them out today, please do take a look at this channel's sponsor, Aura. It's aura.com/TCF. You will find that in the description, and Barbara's been dropping a link in the chat as well. I was reading an article earlier today, actually, about the scam that's going around where people are getting different pieces of identity, and then they are making phone calls claiming to be companies and saying, hey, we've got this package for you that we need to get delivered, but the postage on it was short.
But I can't try to take time.
So anyways, lots of scams. Aura.com/TCF. Keep yourself protected. And he's now unmuted, so let's get back to him.
That we've got you on too.
Yeah, I'm ready on that. That's
What else do you have?
I'm on.
Do you have another plea?
No. It's only play that my other people that show up, and I got some on the jail.
Okay, now let me round out.
I didn't know you said to, he said he would let it, and I didn't know if you wanted to number it or what.
Here's Baylor. That is, how many did I send to Baylor?
It's Templeton, you sent 3 so far, Judge.
Okay, what did I send to Baylor Wortham, the Judge Wortham? Aaron, he said, I thought he said he was gonna do 1 this week.
No, he doesn't have a panel this week. That's why it's just the date. Not panel, something.
Okay, well, here's what we're gonna do is,
Yes.
but this is a trial for sure, right?
Aaron Tyler, yeah, sure.
Okay.
I have Aaron Tyler.
Set that number 2 here. Judge.
Aaron Tyler, huh?
We don't have a number 2 here. I'm gonna set it number 2 here. Okay.
I thought Sean Broussard was 2.
I'll meet you right outside, okay?
That's in Templeton?
You sent me over to something.
That's right, Sarah's in there. Okay, you're number 2 here.
2 here? Okay, sounds good. I'll be back at 1:30 on that. Well, I'm here right now.
And
Just got it.
and what we may end up, if you don't go, I may end up sending you to Judge Wortham on September 15th as a special set.
It's not on me too. But I do have to run.
Okay.
I do have to run the drug police, take care of something. I'll be back for.
Hold on.
Talking.
Is that it?
Yeah, my other guy did not show up.
Okay,
So-
Brittany, you ready?
Yeah, sure. We have an agreement. I'm just waiting to get
Joshua?
a tablet. Yes, sir. He's here.
You waiting on a tab?
Yes, sir.
It's booting up, Judge. Excuse me.
Sweet, I'm a little watch the tree.
Used to be waiting on the little green line to go across the road. Get news. This is into that so long.
All right, well, he awaits his next contestant. Let's go back to Judge Boyd.
All right, and we have an interpreter. If you could raise your right hand. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Arlene Abrams, license number 2081.
All right, Mr. Naranjo, your attorney has filed a motion to withdraw. She believes that you would, it will be easier to communicate if you had someone who spoke Spanish. Is that correct, counsel?
Yes, sir.
All right, do you have any objection to this attorney withdrawing and an attorney be appointed to you who is bilingual?
No.
All right, then your motion to withdraw will be granted. Thank you so much. All right, and then counsel, if you can state your name for the record, please.
Abelardo Garza.
All right, and do you speak Spanish fluently?
Yes, Your Honor.
Right. And are you able to represent Mr. Oscar Orozco Naranjo
Yes, Your Honor.
and Mr. Oscar Naranjo? Do you have any objections to this attorney being appointed to represent you?
Yes. Yes.
All right, this is what I mean. And I'm just going to repeat it because maybe my question wasn't as great as it should be. The previous attorney who was appointed to you did not speak Spanish. This attorney speaks Spanish. So this attorney will be appointed to represent you. Do you understand?
Yes.
All right, then you'll be representing him. And counsel, do you want a reset?
Yes, Your Honor, I'd like time to look at it, discuss it with him, and I need to look at the discovery and see what's going on.
All right, Ms. Ferguson, if I can have a 30-day reset on this, please. All right, you will be brought back on September 29th. And according to the record, your client does have a hold. All right.
Yeah, I got that. The other one. Let's come back tomorrow. Thank you.
All right, as we continue to ping pong back and forth, Judge Stevens has his next contestant.
He failed. He's got THC marijuana positive in his system on the trial docket day. Your bonds are revoked and you're taken into custody, Mr. Harvey, no bond, because this is trial docket day at this time. And was there anything, Mr. Girk tell you what is a backup plan in the event, but this was a trial, right?
Yes.
Okay. All right. It's set for the next trial docket and no bond. He has failed to follow his conditions of bond and tested positive for drugs. That is all. Thank you.
He's still married.
And Robertson, Jeremy Robertson, who am I waiting on that?
Where did you go, guys? That was a plea,
Okay, I didn't mark it off. And I've got all those dismissals. You're going to take care of them for me. Thank you. Jesse Maddox.
Great, Judge.
What are we doing on there?
Sorry. He's failure to register. I'm giving him everything. He insists on the dogs.
Okay, I'm gonna need
Take a look at it.
announcement docket files.
Yes, sir. Do you want the whole stack or want to?
A little at a time.
Okay.
No, I'm just solving this. No one wants to do. Come on, Mr. Maddox.
25 CR 463 is called Jesse Lynn Maddox. That's you?
Yes, sir.
Present with Mr. Adams, your attorney and the state's attorney. You are charged here with a second-degree felony of failing to comply with sex offender registration, which is based upon a conviction of indecency with a child that you acquired in the past. And also paragraph 2 goes on to allege that in 2022, in the court next door, you were convicted as well of failing to comply with sex offender registration. So what this means is this second degree felony of failing to comply with sex offender registration If paragraph 2 is proven true, you're looking at that you have a prior conviction for failing to comply with sex offender registration in the court next door in that clause number 22-40061. You were looking at first degree felony punishment, no less than 5 nor more than life imprisonment. Do you understand what you're facing here?
This here was supposed to have been dropped when I went last time.
It's not dropped, sir. The state's moving forward with it, and this states that this occurred on or about February 26th earlier this year. And that's another offense, a separate offense. You've got to pay a price. You don't. Every individual mistake that's a crime has its own consequences. You understand what you're facing here? All right. All right. Did you want to put something in on?
Yeah, I'll put a record.
Go ahead.
Just for the record, I did give him Mr. Ham's offer of 4 years TDC. I also gave him the police report. I also gave him his indictment with discovery, and it was his decision. Can you tell me you're going to try?
It'll take you 4 years.
Are you going to take it now?
We'll get, man, I can't come over, handcuffed on, damn handcuffs.
Judge, I signed him up. He said he's going to take it now. Back there, he told me no, he wasn't going to take it.
Well, he more information he gets, the more wiser his choice is. That's where everybody can change their mind if they get more information.
That's cool. Judge, if you don't mind, can I set him up right now? Okay. And I can move the case today. So you are gonna take my word.
Yeah, can somebody undo these things? They're still tightening up. I can't even.
Yeah, it's, I'm not in control of that. The executive branch, the sheriff is. We're gonna take whatever it takes for you to be able to sign is what we'll fix, okay? Talk to the lady.
Okay.
All right, thank you.
I'll find him up, Judge. Thanks.
Tom Burbank?
Hey,
Eddie, is Eddie Davis here? Mr. Davis? Hey, let me ask you, are these people on bond?
He's a jail, brother.
This is the jail locket.
Hey. Montreal Lightfoot? That's, it's, okay, Ben Jeffries? We got to you. Good. Reagan, you're next. She's not here. Ashley Nelson.
Yes, Your Honor. We've submitted a motion for a competency evaluation.
I need just that file, please.
Yes, sir.
Please. It's just what happened.
Two of them.
Yes.
Do we need her out or is it him?
It's a.
Yeah, let me just, let's get Miss Nelson.
Need items and documentation saying that she's currently receiving Social Security for mental health issues. But believe that.
Who are you, ma'am?
Nelson.
Okay, you are charged with two cases here, it looks like, in cause number 24 CL 1985. It looks like obstruction or retaliation. Let's see. You intentionally or knowingly threaten to harm another person, a Stephen Nelson, to prevent the delay of service of Stephen Nelson, a person who had reported the occurrence of a crime. And that carries with it up to 10 years in prison if convicted. Do you understand what you're charged with here?
Yes.
And in this is and 24 CR 1986. That is also another obstruction charge alleging on that same day that you knowingly threatened Belinda Nielsen. So each of these cases, you're looking at up to 10 years in prison for if convicted. Do you understand? Serious?
Yeah.
All right. And this case, Mr. Jeffries is your attorney. And I'm looking at a motion that's been filed for competency examination. It says the fact that she might be on disability or for mental health related issues. What is it we're articulating that needs we have evidence that she may be incompetent or possibly insane interactions. I don't know. And struggle to communicate coherent information related to the situation. Every lawyer says that. What is it that's unique here that gives me the option that we should get a licensed psychiatrist? I mean, these are just general allegations. We have to specify and articulate something so that, because everybody can file this motion and be out of money in a day and a half for competency evaluations. What's unique about her situation that needs this, other than just general statements? These are just conclusions. They're just not articulating something or that is unique to her.
I don't know.
Because she's on MR disability, that doesn't do it. That's not enough information for me.
It's just a lot of things that I really can't speak about. I mean, visually, you can see, I've been tortured.
Say that again.
I've been tortured.
Who's tortured?
Everyone just looks like this for.
Yeah, who's been?
Well, I mean, I don't, this was 20 years ago. I mean, I just woke up in a hospital. I don't remember a house fire. I don't think I was gonna try to put a house fire out, with my hands. And I just walked out the front door, woke up, with people mocking me and stuff. I mean, that's how I keep my mouth shut. I don't like getting hurt. And so I don't want that to ever happen again. So I just kind of been taking whatever I can to get by today. That's me. That's mine. I don't believe it's, I mean, a lot of things I just can't really. But yeah, I didn't do right. I know I shouldn't have been over there, but I just don't want to be around those people.
Which people would that be?
Same people out of
The Nelsons?
at the hospital mocking me, and
Who were the Nelsons? Do you remember
that's
that?
allegedly not killing. I mean.
But they're not
just, no, I know I did wrong. If I can just say that I'm a letter from Social Security saying that I can take care of all money, maybe privilege can kind of help me, get on my own feet or whatever. I kind of have a plan, I can move in that little area. I just want to be away from those people. They're not.
Do you live with them?
No, I've been in a hotel since COVID with my 2 dogs, and
Well, how do you interact with them? What situation is it that you have to be?
it's been like kind of abandoned in a hotel, 2 dogs since COVID.
In your honor, I would just note that I have spoken with the complainants or the mother and father of the defendant, and they are also
That's
concerned.
who Stephen Nelson is.
Yes, Your Honor.
And is it Brendan? Belinda, they're your parents.
I stepped with her.
Who's your natural parents?
My mom, she passed away, and she was 42 when she passed.
Well, that's young. What happened?
She died of pneumonia.
Oh,
Yeah, she
it's terrible.
had a drug problem.
How old were you when that happened? Yes, ma'am.
Yeah, they were divorced across the world, but I just don't want to be around all those people. I haven't been, that kind of allowing dogs, but I don't thought they were going to have stable. I know I shouldn't have been over there. I just didn't want to get hurt or hurt each other. I really don't want to hurt them. Whatever I've already taken it out. I don't want to hurt them. I want the best for them and I'll want the best for me, So, but I can just maybe get like a letter to Social Security saying I can take control of my own money. And then get moved if I have to do.
You receive an income, is it Social Security or something?
Yes, I don't want to be on it, but
Yes,
if
ma'am.
you need to be on it, you get to be on, so I didn't want to be on food stamps.
What other income do you have?
I'd like to have a job, you know.
No, now.
That's-
It's just Social Security solely then?
Your Honor, we have offered a deferred. I know Mr. Jeffries just wants to make sure that,
Yeah, I understand.
evaluation.
What I've done in each of these cases is I've granted the motions, and I'm going to ask Dr. Edgar Pond, a licensed psychiatrist, to come and speak with her and evaluate her to make sure that we're not missing something that we can help her get treated, so that when we release her, that you're ready to go into the great outdoors and you're going to be able to take care of yourself without harming yourself or others. That's what's important. Dr. Rapon is going to come speak to you here. It's within a week. He is out there doing that. And then we'll get you back. I want him back in 2 weeks, just so we don't languish, so she doesn't languish, especially if that's where this might proceed. But one way or the other, we want to know which direction she's going to go in quickly to move her out of the jail. Out of the jail's not helping any. That I know.
That's the week of September the 8th.
I don't know. No. Is it? Yeah, I guess it is. Is it 3 weeks better?
No, sir, that works perfect. I think I'm supposed to be here for John.
Okay. All right. Then good luck to you, man. Thank you. Which reminds me on that other case that we had some last week.
Okay, friends, that's the logical place to leave it for today. What an odd day. Court was kind of all over the place. Not exactly happy topics, but you know, it's court. You're not always going to get happy topics. And you know, we started out with that glitch, and I want to thank all of you, by the way. You continue to prove to me every day just how good of a community this is. You know, we went from the pre-show to the main show, and all of a sudden we weren't getting audio from the feeds, and y'all just said it's all right, and you stuck with me while I figured it out, and then followed it up by throwing down 11 gift memberships. So you guys are just amazing. You're the reason why I get up before the sun rises every day, is to be able to spend this time with you. So it means a lot to me, and thank you for always supporting me and having my back. It never goes unnoticed, and I want you to know that. I'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. I will be working on our little glitch, so hopefully it doesn't duplicate itself tomorrow. If there's any inkling that it will, I will leave the new device unplugged as I had to move to today, just to make sure we don't have issues. But again, we'll see you tomorrow. In the meantime, have yourselves a great Monday. Take care. God bless.